Section 38 of The Trial of the Major War Criminals, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Trial of the Major War Criminals before the International Military Tribunal, Nuremberg, 14th November 1945 through 1st October 1946, Volume 1. By the International Military Tribunal. Judgment. Part 18. Schacht. Schacht is indicted under Counts 1 and 2 of the indictment. Schacht served as Commissioner of Currency and President of the Reichsbank from 1923 to 1930, was reappointed President of the Bank on 17th March 1933, Minister of Economics in August 1934, and Plenipotentiary General for War Economy in May 1935. He resigned from these two positions in November 1937 and was appointed Minister without portfolio. He was reappointed as President of the Reichsbank for a one-year term on 16th March 1937 and for a four-year term on 9th March 1938. But was dismissed on 20th January 1939. He was dismissed as Minister without portfolio on 22nd January 1943. Crimes against Peace. Schacht was an active supporter of the Nazi Party before its accession to power on 30th January 1933, and supported the appointment of Hitler to the post of Chancellor. After that date, he played an important role in the vigorous rearmament program which was adopted, using the facilities of the Reichsbank to the fullest extent in the German rearmament effort. The Reichsbank, in its traditional capacity as financial agent for the German government, floated long-term government loans, the proceeds of which were used for rearmament. He devised a system under which 5-year notes, known as MIFO bills, guaranteed by the Reichsbank, and backed, in effect, by nothing more than its position as a bank of issue, were used to obtain large sums for rearmament from the short-term money market. As Minister of Economics and as Plenipotentiary General for War Economy, he was active in organizing the German economy for war. He made detailed plans for industrial mobilization and the coordination of the army with industry in the event of war. He was particularly concerned with shortages of raw materials and started a scheme of stockpiling and a system of exchange control designed to prevent Germany's weak foreign exchange position from hindering the acquisition abroad of raw materials needed for rearmament. On 3rd May 1935, he sent a memorandum to Hitler stating that the accomplishment of the armament program with speed and in quantity is the problem of German politics, that everything else, therefore, should be subordinated to this purpose. Schacht, by April 1936, began to lose his influence as the central figure in the German rearmament effort when Göring was appointed coordinator for raw materials and foreign exchange. Göring advocated a greatly expanded program for the production of synthetic raw materials, which was opposed by Schacht on the ground that the resulting financial strain might involve inflation. The influence of Schacht suffered further when, on 16 October 1936, Göring was appointed plenipotentiary for the four-year plan, with the task of putting the entire economy in a state of readiness for war within 4 years. Schacht had opposed the announcement of this plan and the appointment of Göring to head it, and it is clear that Hitler's action represented a decision that Schacht's economic policies were too conservative for the drastic rearmament policy which Hitler wanted to put into effect. After Göring's appointment, Schacht and Göring promptly became embroiled in a series of disputes. Although there was an element of personal controversy running through these disputes, Schacht disagreed with Göring on certain basic policy issues. Schacht, on financial grounds, advocated a retrenchment in the rearmament program, opposed as uneconomical much of the proposed expansion of production facilities, particularly for synthetics, urged a drastic tightening on government credit and a cautious policy in dealing with Germany's foreign exchange reserves. As a result of this dispute and of a bitter argument in which Hitler accused Schacht of upsetting his plans by his financial methods, Schacht went on leave of absence from the Ministry of Economics on 5 September 1937 and resigned as Minister of Economics and as Plenipotentiary General for War Economy on 16 November 1937. As President of the Reichsbank, Schacht was still involved in disputes. Throughout 1938, the Reichsbank continued to function as the financial agent for the German government in floating long-term loans to finance armaments. But on 23 March 1938, Schacht discontinued the practice of floating short-term notes guaranteed by the Reichsbank for armament expenditures. At the end of 1938, in an attempt to regain control of fiscal policy through the Reichsbank, Schacht refused an urgent request of the Reichsminister of Finance for a special credit to pay the salaries of civil servants which were not covered by existing funds. On 2 January 1939, Schacht held a conference with Hitler at which he urged him to reduce expenditures for armaments. On 7 January 1939, Schacht submitted to Hitler a report signed by the directors of the Reichsbank, which urged a drastic curtailment of armament expenditures and a balanced budget as the only method of preventing inflation. On 19 January, Hitler dismissed Schacht as president of the Reichsbank. On 22 January 1943, Hitler dismissed Schacht as Reichsminister without portfolio because of his whole attitude during the present fateful fight of the German nation. On 23 July 1944, Schacht was arrested by the Gestapo and confined in a concentration camp until the end of the war. It is clear that Schacht was a central figure in Germany's rearmament program, and the steps which he took, particularly in the early days of the Nazi regime, were responsible for Nazi Germany's rapid rise as a military power. But rearmament of itself is not criminal under the Charter. To be a crime against peace under Article 6 of the Charter, it must be shown that Schacht carried out this rearmament as part of the Nazi plans to wage aggressive wars. Schacht has contended that he participated in the rearmament program only because he wanted to build up a strong and independent Germany, which would carry out a foreign policy which would command respect on an equal basis with other European countries. That when he discovered that the Nazis were rearming for aggressive purposes, he attempted to slow down the speed of rearmament, and that after the dismissal of von Fritsch and von Blomberg, he participated in plans to get rid of Hitler, first by deposing him and later by assassination. Schacht, as early as 1936, began to advocate a limitation of the rearmament program for financial reasons. Had the policies advocated by him been put into effect, Germany would not have been prepared for a general European war. Insistence on his policies led to his eventual dismissal from all positions of economic significance in Germany. On the other hand, Schacht, with his intimate knowledge of German finance, was in a peculiarly good position to understand the true significance of Hitler's frantic rearmament, and to realize that the economic policy adopted was consistent only with war as its object. Moreover, Schacht continued to participate in German economic life, and even in a minor way in some of the early Nazi aggressions. Prior to the occupation of Austria, he set a rate of exchange between the mark and the shilling. After the occupation of Austria, he arranged for the incorporation of the Austrian National Bank into the Reichsbank and made a violently pro-Nazi speech in which he stated that the Reichsbank would always be Nazi as long as he was connected with it, praised Hitler, defended the occupation of Austria, scoffed at objections to the way it was carried out, and ended with "To our Führer a triple Sieg Heil." He has not contended that this speech did not represent his state of mind at the time. After the occupation of the Sudetenland, he arranged for currency conversion and for the incorporation into the Reichsbank of local Czech banks of issue. On 29 November 1938, he made a speech in which he pointed with pride to his economic policy, which had created the high degree of German armament, and added that this armament had made Germany's foreign policy possible. Schacht was not involved in the planning of any of the specific wars of aggression charged in Count 2. His participation in the occupation of Austria and the Sudetenland, neither of which are charged as aggressive wars, was on such a limited basis that it does not amount to participation in the common plan charged in Count 1. He was clearly not one of the inner circle around Hitler which was most closely involved with this common plan. He was regarded by this group with undisguised hostility. The testimony of Speer shows that Schacht's arrest on 23 July 1944 was based as much on Hitler's enmity towards Schacht growing out of his attitude before the war as it was on suspicion of his complicity in the bomb plot. The case against Schacht therefore depends on the inference that Schacht did in fact know of the Nazi aggressive plans. On this all-important question, evidence has been given for the prosecution and a considerable volume of evidence for the defense. The tribunal has considered the whole of this evidence with great care and comes to the conclusion that this necessary inference has not been established beyond a reasonable doubt. Conclusion. The tribunal finds that Schacht is not guilty on this indictment and directs that he shall be discharged by the marshal when the tribunal presently adjourns. Dönitz. Dönitz is indicted on counts 1, 2, and 3. In 1935, he took command of the first U-boat flotilla commissioned since 1918, became in 1936 commander of the submarine arm, was made vice admiral in 1940, admiral in 1942, and on 30th January 1943, commander-in-chief of the German Navy. On 1st May 1945, he became the head of state, succeeding Hitler. Crimes against peace. Although Dönitz built and trained the German U-boat arm, the evidence does not show he was privy to the conspiracy to wage aggressive wars or that he prepared and initiated such wars. He was a line officer performing strictly tactical duties. He was not present at the important conferences when plans for aggressive wars were announced, and there is no evidence he was informed about the decisions reached there. Dönitz did, however, wage aggressive war within the meaning of that word as used by the Charter. Submarine warfare, which began immediately upon the outbreak of war, was fully coordinated with the other branches of the Wehrmacht. It is clear that his U-boats, few in number at the time, were fully prepared to wage war. It is true that until his appointment in January 1943 as Commander-in-Chief, he was not an Oberbefehlshaber. But this statement underestimates the importance of Dönitz's position. He was no mere army or division commander. The U-boat arm was the principal part of the German fleet, and Dönitz was its leader. The High Seas Fleet made a few minor, if spectacular, raids during the early years of the war, but the real damage to the enemy was done almost exclusively by his submarines, as the millions of tons of Allied and neutral shipping sunk will testify. Dönitz was solely in charge of this warfare. The Naval War Command reserved for itself only the decision as to the number of submarines in each area. In the invasion of Norway, for example, Dönitz made recommendations in October 1939 as to submarine bases, which he claims were no more than a staff study, and in March 1940 he made out the operational orders for the supporting U-boats, as discussed elsewhere in this judgment. That his importance to the German war effort was so regarded is eloquently proved by Raeder's recommendation of Dönitz as his successor and his appointment by Hitler on 30th January 1943 as Commander-in-Chief of the Navy. Hitler, too, knew that submarine warfare was the essential part of Germany's naval warfare. From January 1943, Dönitz was consulted almost continuously by Hitler. The evidence was that they conferred on naval problems about 120 times during the course of the war. As late as April 1945, when he admits he knew the struggle was hopeless, Dönitz, as its commander-in-chief, urged the Navy to continue its fight. On 1 May 1945, he became the head of state and as such ordered the Wehrmacht to continue its war in the East until capitulation on 9 May 1945. Dönitz explained that his reason for these orders was to ensure that the German civilian population might be evacuated and the army might make an orderly retreat from the East. In the view of the tribunal, the evidence shows that Dönitz was active in waging aggressive war. War crimes. Dönitz is charged with waging unrestricted submarine warfare contrary to the Naval Protocol of 1936, to which Germany acceded, and which reaffirmed the rules of submarine warfare laid down in the London Naval Agreement of 1930. The prosecution has submitted that on 3 September 1939, the German U-boat arm began to wage unrestricted submarine warfare upon all merchant ships, whether enemy or neutral, cynically disregarding the protocol, and that a calculated effort was made throughout the war to disguise this practice by making hypocritical references to international law and supposed violations by the Allies. Dönitz insists that at all times the Navy remained within the confines of international law and of the protocol. He testified that when the war began, the guide to submarine warfare was the German prize ordinance taken almost literally from the protocol, that pursuant to the German view, he ordered submarines to attack all merchant ships in convoy and all that refused to stop or use their radio upon sighting a submarine. When his reports indicated that British merchant ships were being used to give information by wireless, were being armed, and were attacking submarines on sight, he ordered his submarines on 17 October 1939 to attack all enemy merchant ships without warning, on the ground that resistance was to be expected. Orders already had been issued on 21 September 1939 to attack all ships, including neutrals, sailing at night without lights in the English Channel. On 29 November 1939, the German government issued a warning to neutral shipping that, owing to the frequent engagements taking place in the waters around the British Isles and the French coast, between U-boats and Allied merchant ships, which were armed and had instructions to use those arms as well as to ram U-boats, the safety of neutral ships in those waters could no longer be taken for granted. On 1 January 1940, the German U-boat command, acting on the instructions of Hitler, ordered U-boats to attack all Greek merchant ships in the zone surrounding the British Isles, which was banned by the United States to its own ships, and also merchant ships of every nationality in the limited area of the Bristol Channel. 5 days later, a further order was given to U-boats to make immediately unrestricted use of weapons against all ships in an area of the North Sea, the limits of which were defined. Finally, on 18 January 1940, U-boats were authorized to sink without warning all ships in those waters near the enemy coasts in which the use of mines can be pretended. Exceptions were to be made in the case of United States, Italian, Japanese, and Soviet ships. Shortly after the outbreak of war, the British Admiralty, in accordance with its Handbook of Instructions of 1938 to the Merchant Navy, armed its merchant vessels, in many cases convoyed them with armed escorts, gave orders to send position reports upon sighting submarines, thus integrating merchant vessels into the warning network of naval intelligence. On 1 October 1939, the British Admiralty announced that British merchant ships had been ordered to ram U-boats if possible. In the actual circumstances of this case, The tribunal is not prepared to hold Dönitz guilty for his conduct of submarine warfare against British armed merchant ships. However, the proclamation of operational zones and the sinking of neutral merchant vessels which enter those zones presents a different question. This practice was employed in the War of 1914-18 by Germany and adopted in retaliation by Great Britain. The Washington Conference of 1922, the London Naval Agreement of 1930, and the Protocol of 1936 were entered into with full knowledge that such zones had been employed in the First World War. Yet the Protocol made no exception for operational zones. The order of Dönitz to sink neutral ships without warning when found within these zones was therefore, in the opinion of the tribunal, a violation of the Protocol. It is also asserted that the German U-boat arm not only did not carry out the warning and rescue provisions of the Protocol, but that Dönitz deliberately ordered the killing of survivors of shipwrecked vessels, whether enemy or neutral. The prosecution has introduced much evidence surrounding two orders of Dönitz, War Order No. 154, issued in 1939, and the so-called Laconia Order of 1942. The defense argues that these orders and the evidence supporting them do not show such a policy, and introduced much evidence to the contrary. The tribunal is of the opinion that the evidence does not establish with the certainty required that Dönitz deliberately ordered the killing of shipwrecked survivors. The orders were undoubtedly ambiguous and deserve the strongest censure. The evidence further shows that the rescue provisions were not carried out, and that the defendant ordered that they should not be carried out. The argument of the defense is that the security of the submarine is, as the first rule of the sea, paramount to rescue, and that the development of aircraft made rescue impossible. This may be so, but the Protocol is explicit. If the commander cannot rescue, then, under its terms, he cannot sink a merchant vessel and should allow it to pass harmless before his periscope. These orders, then, prove Dönitz is guilty of a violation of the Protocol. In view of all the facts proved, and in particular of an order of the British Admiralty announced on 8 May 1940, according to which all vessels should be sunk at night in the Skagerrak, and the answers to interrogatories by Admiral Nimitz, stating that unrestricted submarine warfare was carried on in the Pacific Ocean by the United States from the first day that nation entered the war, the sentence of Dönitz is not assessed on the ground of his breaches of the international law of submarine warfare. Dönitz was also charged with responsibility for Hitler's commando order of 18 October 1942. Dönitz admitted he received and knew of the order when he was flag officer of U-boats, but disclaimed responsibility. He points out that the order, by its express terms, excluded men captured in naval warfare, that the Navy had no territorial command on land, and that submarine commanders would never encounter commandos. In one instance, when he was Commander-in-Chief of the Navy in 1943, the members of the crew of an Allied motor torpedo boat were captured by German naval forces. They were interrogated for intelligence purposes on behalf of the local admiral, and then turned over by his order to the SD and shot. Dönitz said that if they were captured by the Navy, their execution was a violation of the commando order, that the execution was not announced in the Wehrmacht communique, and that he was never informed of the incident. He pointed out that the admiral in question was not in his chain of command, but was subordinate to the army general in command of the Norway occupation. But Dönitz permitted the order to remain in full force when he became Commander-in-Chief, and to that extent he is responsible. Dönitz, in a conference of 11th December 1944, said 12,000 concentration camp prisoners will be employed in the shipyards as additional labor. At this time, Dönitz had no jurisdiction over shipyard construction, and claims that this was merely a suggestion at the meeting that the responsible officials do something about the production of ships, that he took no steps to get these workers, since it was not a matter for his jurisdiction, and that he does not know whether they were ever procured. He admits he knew of concentration camps. A man in his position must necessarily have known that citizens of occupied countries in large numbers were confined in the concentration camps. In 1945, Hitler requested the opinion of Jodl and Dönitz whether the Geneva Convention should be denounced. The notes of the meeting between the two military leaders on 20th February 1945 show that Dönitz expressed his view that the disadvantages of such an action outweighed the advantages. The summary of Dönitz's attitude, shown in the notes taken by an officer, included the following sentence: "It would be better to carry out the measures considered necessary without warning and at all costs to save face with the outer world." The prosecution insists that the measures referred to meant the convention should not be denounced, but should be broken at will. The defense explanation is that Hitler wanted to break the convention for two reasons: to take away from German troops the protection of the convention, thus preventing them from continuing to surrender in large groups to British and Americans, and also to permit reprisals against Allied prisoners of war because of Allied bombing raids. Dönitz claims that what he meant by measures were disciplinary measures against German troops to prevent them from surrendering, and that his words had no reference to measures against the Allies. Moreover, that this was merely a suggestion, and that in any event no such measures were ever taken, either against Allies or Germans. The tribunal, however, does not believe this explanation. The Geneva Convention was not, however, denounced by Germany. The defense has introduced several affidavits to prove that British naval prisoners of war in camps under Dönitz's jurisdiction were treated strictly according to the convention, and the tribunal takes this fact into consideration, regarding it as a mitigating circumstance. Conclusion. The tribunal finds Dönitz is not guilty on count 1 of the indictment and is guilty on counts 2 and 3. End of section 38. Recording by Maria Kasper. Section 39 of The Trial of the Major War Criminals, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Trial of the Major War Criminals before the International Military Tribunal, Nuremberg, 14th November 1945 to 1st October 1946, Volume 1, by the International Military Tribunal. Judgment, Part 19. Raeder. Raeder is indicted on counts 1, 2, and 3. In 1928, he became Chief of Naval Command, and in 1935, Oberbefehlshaber der Kriegsmarine, OKM. In 1939, Hitler made him Gross Admiral. He was a member of the Reich Defense Council. On 30th January 1943, Dönitz replaced him at his own request, and he became Inspector Admiral of the Navy, a nominal title. Crimes against peace. In the 15 years he commanded it, Raeder built and directed the German Navy. He accepts full responsibility until retirement in 1943. He admits the Navy violated the Versailles Treaty, insisting it was a matter of honor for every man to do so, and alleges that the violations were for the most part minor, and Germany built less than her allowable strength. These violations, as well as those of the Anglo-German Naval Agreement of 1935, have already been discussed elsewhere in this judgment. Raeder received the directive of 24th June 1937 from von Blomberg, requiring special preparations for war against Austria. He was one of the 5 leaders present at the Hossbach Conference of 5th November 1937. He claims Hitler merely wished by this conference to spur the army to faster rearmament. insists he believed the questions of Austria and Czechoslovakia would be settled peacefully, as they were, and points to the new naval treaty with England which had just been signed. He received no orders to speed construction of U-boats, indicating that Hitler was not planning war. Raeder received directions on Fall Grün and the directives on Fall Weiss, beginning with that of 3rd April 1939. The latter directed the Navy to support the Army by intervention from the sea. He was also one of the few chief leaders present at the meeting of 23rd May 1939. He attended the Ober-Salzburg briefing of 22nd August 1939. The conception of the invasion of Norway first arose in the mind of Raeder and not that of Hitler. Despite Hitler's desire, as shown by his directive of October 1939, to keep Scandinavia neutral, the Navy examined the advantages of naval bases there as early as October. Admiral Karls originally suggested to Raeder the desirable aspects of bases in Norway. A questionnaire dated 3rd October 1939, which sought comments on the desirability of such bases, was circulated within SKL. On 10th October, Raeder discussed the matter with Hitler. His war diary entry for that day says Hitler intended to give the matter consideration. A few months later, Hitler talked to Raeder, Quisling, Keitel, and Jodl. OKW began its planning, and the Naval War Staff worked with OKW staff officers. Raeder received Keitel's directive for Norway on 27 January 1940, and the subsequent directive of 1 March, signed by Hitler. Raeder defends his actions on the grounds that it was a move to forestall the British. It is not necessary again to discuss this defense, which has heretofore been treated in some detail, concluding that Germany's invasion of Norway and Denmark was aggressive war. In a letter to the Navy, Raeder said, "The operations of the Navy in the occupation of Norway will for all time remain the great contribution of the Navy to this war." Raeder received the directives, including the innumerable postponements, for the attack in the West. In a meeting of 18 March 1941 with Hitler, he urged the occupation of all Greece. He claims this was only after the British had landed and Hitler had ordered the attack, and points out the Navy had no interest in Greece. He received Hitler's directive on Yugoslavia. Raeder endeavored to dissuade Hitler from embarking upon the invasion of the USSR. In September 1940, he urged on Hitler an aggressive Mediterranean policy as an alternative to an attack on Russia. On 14 November 1940, he urged the war against England as our main enemy, and that submarine and naval air force construction be continued. He voiced serious objections against the Russian campaign before the defeat of England, according to notes of the German Naval War Staff. He claims his objections were based on the violation of the Non-Aggression Pact as well as strategy. But once the decision had been made, he gave permission 6 days before the invasion of the Soviet Union to attack Russian submarines in the Baltic Sea within a specified warning area, and defends this action because these submarines were snooping on German activities. It is clear from this evidence that Raeder participated in the planning and waging of aggressive war. War crimes. Raeder is charged with war crimes on the high seas. The Athenia, an unarmed British passenger liner, was sunk on 3 September 1939 while outward bound to America. The Germans 2 months later charged that Mr. Churchill deliberately sank the Athenia to encourage American hostility to Germany. In fact, it was sunk by the German U-boat 30. Raeder claims that an inexperienced U-boat commander sank it in mistake for an armed merchant cruiser, that this was not known until the U-30 returned several weeks after the German denial, and that Hitler then directed the Navy and Foreign Office to continue denying it. Raeder denied knowledge of the propaganda campaign attacking Mr. Churchill. The most serious charge against Raeder is that he carried out unrestricted submarine warfare, including the sinking of unarmed merchant ships, of neutrals, non-rescue and machine gunning of survivors, contrary to the London Protocol of 1936. The tribunal makes the same finding on Raeder on this charge as it did to Dönitz, which has already been announced, up to 30th January 1943 when Raeder retired. The Commando Order of 18th October 1942, which expressly did not apply to naval warfare, was transmitted by the Naval War Staff to the lower naval commanders with the direction it should be distributed orally by flotilla leaders and section commanders to their subordinates. 2 commandos were put to death by the Navy, and not the SD, at Bordeaux on 10th December 1942. The comment of the Naval War Staff was that this was in accordance with the Führer's special order, but is nevertheless something new in international law, since the soldiers were in uniform. Raeder admits he passed the order down through the chain of command, and he did not object to Hitler. Conclusion. The tribunal finds that Raeder is guilty on counts 1, 2, and 3. Von Schirach. Von Schirach is indicted under counts 1 and 4. He joined the Nazi Party and the SA in 1925. In 1929, he became the leader of the National Socialist Students' Union. In 1931, he was made Reich's youth leader of the Nazi Party, with control over all Nazi youth organizations, including the Hitlerjugend. In 1933, after the Nazis had obtained control of the government, von Schirach was made leader of youth in the German Reich, originally a position within the Ministry of the Interior, but after 1st December 1936, an office in the Reich Cabinet. In 1940, von Schirach resigned as head of the Hitlerjugend and leader of youth in the German Reich, but retained his position as Reichsleiter with control over youth education. In 1940, he was appointed Gauleiter of Vienna, Reichsgovernor of Vienna, and Reich's Defense Commissioner for that territory. Crimes against peace. After the Nazis had come to power, von Schirach, utilizing both physical violence and official pressure, either drove out of existence or took over all youth groups which competed with the Hitlerjugend. A Hitler decree of 1st December 1936 incorporated all German youth within the Hitlerjugend. By the time formal conscription was introduced in 1940, 97% of those eligible were already members. Von Schirach used the Hitlerjugend to educate German youth in the spirit of National Socialism and subjected them to an intensive program of Nazi propaganda. He established the Hitlerjugend as a source of replacements for the Nazi Party formations. In October 1938, he entered into an agreement with Himmler under which members of the Hitlerjugend who met SS standards would be considered as the primary source of replacements for the SS. Von Schirach also used the Hitlerjugend for pre-military training. Special units were set up whose primary purpose was training specialists for the various branches of the service. On 11th August 1939, he entered into an agreement with Keitel, under which the Hitlerjugend agreed to carry out its pre-military activities under standards laid down by the Wehrmacht, and the Wehrmacht agreed to train 30,000 Hitlerjugend instructors each year. The Hitlerjugend placed particular emphasis on the military spirit, and the training program stressed the importance of return of the colonies, the necessity for Lebensraum, and the noble destiny of German youth to die for Hitler. Despite the warlike nature of the activities of the Hitlerjugend, however, it does not appear that von Schirach was involved in the development of Hitler's plan for territorial expansion by means of aggressive war, or that he participated in the planning or preparation of any of the wars of aggression. Crimes against humanity. In July 1940, von Schirach was appointed Gauleiter of Vienna. At the same time, he was appointed Reichsgovernor for Vienna and Reich's Defense Commissioner, originally for Military District 17, including the Gau of Vienna, Upper Danube, and Lower Danube, and after 17th November 1942 for the Gau of Vienna alone. As Reich's Defense Commissioner, he had control of the civilian war economy. As Reich's governor, he was head of the municipal administration of the city of Vienna, and under the supervision of the Minister of the Interior, in charge of the governmental administration of the Reich in Vienna. Von Schirach is not charged with the commission of war crimes in Vienna, only with the commission of crimes against humanity. As has already been seen, Austria was occupied pursuant to a common plan of aggression. Its occupation is therefore a crime within the jurisdiction of the tribunal, as that term is used in Article 6c of the Charter. As a result, murder, extermination, enslavement, deportation, and other inhumane acts, and persecutions on political, racial, or religious grounds in connection with this occupation constitute a crime against humanity under that article. As Gauleiter of Vienna, von Schirach came under the Sauckel Decree, dated 6th April 1942, making the Gauleiters Sauckel's plenipotentiaries for manpower with authority to supervise the utilization and treatment of manpower within their Gau. Sauckel's directives provided that the forced laborers were to be fed, sheltered, and treated so as to exploit them to the highest possible degree at the lowest possible expense. When von Schirach became Gauleiter of Vienna, the deportation of the Jews had already been begun, and only 60,000 out of Vienna's original 190,000 Jews remained. On 2nd October 1940, he attended a conference at Hitler's office and told Frank that he had 50,000 Jews in Vienna which the general government would have to take over from him. On 3rd December 1940, von Schirach received a letter from Lammers stating that after the receipt of the reports made by von Schirach, Hitler had decided to deport the 60,000 Jews still remaining in Vienna to the general government because of the housing shortage in Vienna. The deportation of the Jews from Vienna was then begun and continued until the early fall of 1942. On 15th September 1942, von Schirach made a speech in which he defended his action in having driven tens of thousands upon tens of thousands of Jews into the ghetto of the East as contributing to European culture. While the Jews were being deported from Vienna, reports addressed to him in his official capacity were received in von Schirach's office from the Office of the Chief of the Security Police and SD, which contained a description of the activities of Einsatzgruppen in exterminating Jews. Many of these reports were initialed by one of von Schirach's principal deputies. On 30th June 1944, von Schirach's office also received a letter from Kaltenbrunner informing him that a shipment of 12,000 Jews was on its way to Vienna for essential war work, and that all those who were incapable of work would have to be kept in readiness for special action. The tribunal finds that von Schirach, while he did not originate the policy of deporting Jews from Vienna, participated in this deportation after he had become Gauleiter of Vienna. He knew that the best the Jews could hope for was a miserable existence in the ghettos of the East. Bulletins describing the Jewish extermination were in his office. While Gauleiter of Vienna, von Schirach continued to function as Reichsleiter for youth education, and in this capacity he was informed of the Hitlerjugend's participation in the plan put into effect in the fall of 1944, under which 50,000 young people between the ages of 10 and 20 were evacuated into Germany from areas recaptured by the Soviet forces and used as apprentices in German industry and as auxiliaries in units of the German armed forces. In the summer of 1942, von Schirach telegraphed Bormann urging that a bombing attack on an English cultural town be carried out in retaliation for the assassination of Heydrich, which he claimed had been planned by the British. Conclusion. The tribunal finds that von Schirach is not guilty on count 1. He is guilty under count 4. Sauckel. Sauckel is indicted under all 4 counts. Sauckel joined the Nazi Party in 1923 and became Gauleiter of Thuringia in 1927. He was a member of the Thuringian legislature from 1927 to 1933, was appointed Reichsstatthalter for Thuringia in 1932, and Thuringian Minister of the Interior and head of the Thuringian State Ministry in May 1933. He became a member of the Reichstag in 1933. He held the formal rank of Obergruppenführer in both the SA and the SS. Crimes against the peace. The evidence has not satisfied the tribunal that Sauckel was sufficiently connected with the common plan to wage aggressive war, or sufficiently involved in the planning or waging of the aggressive wars, to allow the tribunal to convict him on counts 1 or 2. War crimes and crimes against humanity. On 21 March 1942, Hitler appointed Sauckel Plenipotentiary General for the Utilization of Labor, with authority to put under uniform control the utilization of all available manpower, including that of workers recruited abroad and of prisoners of war. Sauckel was instructed to operate within the fabric of the 4-year plan, and on 27 March 1942, Göring issued a decree as commissioner for the 4-year plan, transferring his manpower sections to Sauckel. On 30 September 1942, Hitler gave Sauckel authority to appoint commissioners in the various occupied territories and to take all necessary measures for the enforcement of the decree of 21 March 1942. Under the authority which he obtained by these decrees, Sauckel set up a program for the mobilization of the labor resources available to the Reich. One of the important parts of this mobilization was the systematic exploitation by force of the labor resources of the occupied territories. Shortly after Sauckel had taken office, he had the governing authorities in the various occupied territories issue decrees establishing compulsory labor service in Germany. Under the authority of these decrees, Sauckel's commissioners, backed up by the police authorities of the occupied territories, obtained and sent to Germany the laborers which were necessary to fill the quotas given them by Sauckel. He described so-called voluntary recruiting by a whole batch of male and female agents, just as was done in the olden times for Shanghaiing. That real voluntary recruiting was the exception rather than the rule is shown by Sauckel's statement on 1 March 1944 that out of 5 million foreign workers who arrived in Germany, not even 200,000 came voluntarily. Although he now claims that the statement is not true, the circumstances under which it was made, as well as the evidence presented before the tribunal, leave no doubt that it was substantially accurate. The manner in which the unfortunate slave laborers were collected and transported to Germany, and what happened to them after they arrived, has already been described. Sauckel argues that he is not responsible for these excesses in the administration of the program. He says that the total number of workers to be obtained was set by the demands from agriculture and from industry, that obtaining the workers was the responsibility of the occupation authorities, transporting them to Germany, that of the German railways, and taking care of them in Germany, that of the Ministries of Labor and Agriculture, the German Labor Front, and the various industries involved. He testifies that insofar as he had any authority, he was constantly urging humane treatment. There is no doubt, however, that Sauckel had overall responsibility for the slave labor program. At the time of the events in question, he did not fail to assert control over the fields which he now claims were the sole responsibility of others. His regulations provided that his commissioners should have authority for obtaining labor, and he was constantly in the field supervising the steps which were being taken. He was aware of the ruthless methods being taken to obtain laborers, and vigorously supported them on the ground that they were necessary to fill the quotas. Sauckel's regulations also provided that he had responsibility for transporting the laborers to Germany, allocating them to employers, and taking care of them, and that the other agencies involved in these processes were subordinate to him. He was informed of the bad conditions which existed. It does not appear that he advocated brutality for its own sake, or was an advocate of any program such as Himmler's plan for extermination through work. His attitude was thus expressed in a regulation: all the men must be fed, sheltered, and treated in such a way as to exploit them to the highest possible extent at the lowest conceivable degree of expenditure. The evidence shows that Sauckel was in charge of a program which involved deportation for slave labor of more than 5 million human beings, many of them under terrible conditions of cruelty and suffering. Conclusion. The Tribunal finds that Sauckel is not guilty on counts 1 and 2. He is guilty under counts 3 and 4. End of section 39. Recording by Maria Kasper. Section 40 of The Trial of the Major War Criminals, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Trial of the Major War Criminals before the International Military Tribunal, Nuremberg, 14th November 1945 through 1st October 1946, Volume 1, by the International Military Tribunal. Judgment, Part 20. Jodl. Jodl is indicted on all 4 counts. From 1935 to 1938, he was chief of the National Defense Section in the High Command. After a year in command of troops, in August 1939, he returned to become chief of the operations staff of the High Command of the Armed Forces. Although his immediate superior was Defendant Keitel, he reported directly to Hitler on operational matters. In the strict military sense, Jodl was the actual planner of the war and responsible in a large measure for the strategy and conduct of operations. Jodl defends himself on the ground he was a soldier sworn to obedience and not a politician, and that his staff and planning work left him no time for other matters. He said that when he signed or initialed orders, memoranda, and letters, he did so for Hitler and often in the absence of Keitel. Though he claims that as a soldier he had to obey Hitler, he says that he often tried to obstruct certain measures by delay, which occasionally proved successful, as when he resisted Hitler's demand that a directive be issued to lynch Allied terror flyers. Crimes against peace. Entries in Jodl's diary of 13th and 14th February 1938 show Hitler instructed both him and Keitel to keep up military pressure against Austria, begun at the Schuschnigg Conference, by simulating military measures, and that these achieved their purpose. When Hitler decided not to tolerate Schuschnigg's plebiscite, Jodl brought to the conference the old draft, the existing staff plan. His diary for 10th March shows Hitler then ordered the preparation of Case Otto, and the directive was initialed by Jodl. Jodl issued supplementary instructions on 11th March and initialed Hitler's order for the invasion on the same date. In planning the attack on Czechoslovakia, Jodl was very active, according to the Schmundt notes. He initialed items 14, 17, 24, 36, and 37 in the notes. Jodl admits he agreed with OKH that the incident, to provide German intervention, must occur at the latest by 1400 on X-1 day, the day before the attack, and said it must occur at a fixed time in good flying weather. Jodl conferred with the propaganda experts on imminent common tasks such as German violations of international law, exploitation of them by the enemy, and refutations by the Germans, which task Jodl considered particularly important. After Munich, Jodl wrote, "Czechoslovakia as a power is out. The genius of the Führer and his determination not to shun even a world war have again won the victory without the use of force. The hope remains that the incredulous, the weak, and the doubtful people have been converted and will remain that way. Shortly after the Sudeten occupation, Jodl went to a post command and did not become chief of the operations staff in OKW until the end of August 1939. Jodl discussed the Norway invasion with Hitler, Keitel, and Raeder on 12 December 1939. His diary is replete with late entries on his activities in preparing this attack. Jodl explains his comment that Hitler was still looking for an excuse to move, meant that he was waiting for reliable evidence on the British plans, and defends the invasion as a necessary move to forestall them. His testimony shows that from October 1939, Hitler planned to attack the West through Belgium, but was doubtful about invading Holland until the middle of November. On 8 February 1940, Jodl, his deputy Warlimont, and Jeschonek, the Air Force's planner, discussed among themselves the new idea of attacking Norway, Denmark, and Holland, but guaranteeing the neutrality of Belgium. Many of the 17 orders postponing the attack in the West for various reasons, including weather conditions, until May 1940 were signed by Jodl. He was active in the planning against Greece and Yugoslavia. The Hitler order of 11th January 1941 to intervene in Albania was initialed by Jodl. On 20th January, 4 months before the attack, Hitler told a conference of German and Italian generals in Jodl's presence that German troop concentrations in Romania were to be used against Greece. Jodl was present on 18th March when Hitler told Raeder all Greece must be occupied before any settlement could be reached. On 27th March, when Hitler told the German High Command that the destruction of Yugoslavia should be accomplished with unmerciful harshness, and the decision was taken to bomb Belgrade without a declaration of war, Jodl was also there. Jodl testified that Hitler feared an attack by Russia and so attacked first. This preparation began almost a year before the invasion. Jodl told Warlimont as early as 29 July 1940 to prepare the plans, since Hitler had decided to attack, and Hitler later told Warlimont he had planned to attack in August 1940, but postponed it for military reasons. He initialed Hitler's directive of 12 November 1940 that preparations verbally ordered should be continued, and also initialed Case Barbarossa on 18 December. On 3 February 1941, Hitler, Jodl, and Keitel discussed the invasion, and he was present on 14 June when final reports on Case Barbarossa were made. War crimes and crimes against humanity. On 18 October 1942, Hitler issued the Commando Order, and a day later a supplementary explanation to commanding officers only. The covering memorandum was signed by Jodl. Early drafts of the order were made by Jodl's staff with his knowledge. Jodl testified he was strongly opposed on moral and legal grounds, but could not refuse to pass it on. He insists he tried to mitigate its harshness in practice by not informing Hitler when it was not carried out. He initialed the OKW Memorandum of 25 June 1944, reaffirming the order after the Normandy landings. A plan to eliminate Soviet commissars was in the directive for Case Barbarossa. The decision whether they should be killed without trial was to be made by an officer. A draft contains Jodl's handwriting suggesting this should be handled as retaliation, and he testified this was his attempt to get around it. When in 1945 Hitler considered denouncing the Geneva Convention, Jodl argued the disadvantages outweighed the advantages. On 21 February, he told Hitler adherence to the convention would not interfere with the conduct of the war, giving as an example the sinking of a British hospital ship as a reprisal and calling it a mistake. He said he did so because it was the only attitude Hitler would consider, that moral or legal arguments had no effect, and argues he thus prevented Hitler from denouncing the convention. There is little evidence that Jodl was actively connected with the slave labor program, and he must have concentrated on his strategic planning function. But in his speech of 7th November 1943 to the Gauleiters, he said it was necessary to act with remorseless vigor and resolution in Denmark, France, and the Low Countries to compel work on the Atlantic Wall. By teletype on 28 October 1944, Jodl ordered the evacuation of all persons in northern Norway and burning of their houses so they could not help the Russians. Jodl says he was against this, but Hitler ordered it, and it was not fully carried out. A document of the Norwegian government says such an evacuation did take place in northern Norway, and 30,000 houses were damaged. On 7th October 1941, Jodl signed an order that Hitler would not accept an offer of surrender of Leningrad or Moscow, but on the contrary he insisted that they be completely destroyed. He says this was done because the Germans were afraid those cities would be mined by the Russians, as was Kiev. No surrender was ever offered. His defense, in brief, is the doctrine of superior orders, prohibited by Article 8 of the Charter as a defense. There is nothing in mitigation. Participation in such crimes as these has never been required of any soldier, and he cannot now shield himself behind a mythical requirement of soldierly obedience at all costs as his excuse for commission of these crimes. Conclusion. The tribunal finds that Jodl is guilty on all 4 counts. Von Papen. Von Papen is indicted under counts 1 and 2. He was appointed Chancellor of the Reich on 1 June 1932 and was succeeded by von Schleicher on 2 December 1932. He was made Vice-Chancellor in the Hitler Cabinet on 30th January 1933, and on 13th November 1933, plenipotentiary for the Tsar. On 26 July 1934, he was appointed minister to Vienna and was recalled on 4 February 1938. On 29 April 1939, he was appointed ambassador to Turkey. He returned to Germany when Turkey broke off diplomatic relations with Germany in August 1944. Crimes against peace. Von Papen was active in 1932 and 33 in helping Hitler to form the coalition cabinet and aided in his appointment as Chancellor on 30th January 1933. As Vice-Chancellor in that cabinet, he participated in the Nazi consolidation of control in 1933. On 16th June 1934, however, von Papen made a speech at Marburg which contained a denunciation of the Nazi attempts to suppress the free press and the church, of the existence of a reign of terror, and of 150% Nazis who were mistaking brutality for vitality. On 30th June 1934, in the wave of violence which accompanied the so-called Röhm Purge, von Papen was taken into custody by the SS. His office force was arrested, and 2 of his associates, including the man who had helped him work on the Marburg speech, were murdered. Von Papen was released on 3 July 1934. Notwithstanding the murder of his associates, von Papen accepted the position of Minister to Austria on 26 July 1934, the day after Dollfuss had been assassinated. His appointment was announced in a letter from Hitler, which instructed him to direct relations between the 2 countries into normal and friendly channels, and assured him of Hitler's complete and unlimited confidence. As Minister to Austria, von Papen was active in trying to strengthen the position of the Nazi Party in Austria for the purpose of bringing about Anschluss. In early 1935, he attended a meeting in Berlin at which the policy was laid down to avoid everything which would give the appearance of German intervention in the internal affairs of Austria. Yet he arranged for 200,000 marks a month to be transmitted to the persecuted National Socialist sufferers in Austria. On 17 May 1935, he reported to Hitler the results of a conference with Captain Leopold, the leader of the Austrian Nazis, and urged Hitler to make a statement recognizing the national independence of Austria and predicting that the result might be to help the formation of a coalition between Schuschnigg's Christian Socialists and the Austrian Nazis against Starhemberg. On 27 July 1935, von Papen reported to Hitler that the union of Austria and Germany could not be brought about by external pressure, but only by the strength of the National Socialist movement. He urged that the Austrian Nazi Party change its character as a centralized Reich German party and become a rallying point for all national Germans. Von Papen was involved in occasional Nazi political demonstrations, supported Nazi propaganda activities, and submitted detailed reports on the activities of the Nazi Party and routine reports relating to Austrian military defenses. His Austrian policy resulted in the agreement of 11 July 1936, which nominally restored relations between Germany and Austria to normal and friendly form, but which had a secret supplement providing for an amnesty for Austrian Nazis, the lifting of censorship on Nazi papers, the resumption of political activities by Nazis, and the appointment of men friendly to the Nazis in the Schuschnigg cabinet. After the signing of this agreement, von Papen offered to resign, but his resignation was not accepted. Thereafter he proceeded to bring continued pressure on the Austrian government to bring Nazis into the Schuschnigg cabinet and to get them important positions in the Fatherland Front, Austria's single legal party. On 1 September 1936, von Papen wrote Hitler advising him that anti-Nazis in the Austrian Ministry of Security were holding up the infiltration of the Nazis into the Austrian government and recommended bringing slowly intensified pressure directed at changing the regime. On 4 February 1938, von Papen was notified of his recall as minister to Austria, at the same time that von Fritsch, von Blomberg, and von Neurath were removed from their positions. He informed Hitler that he regretted his recall because he had been trying since November 1937 to induce Schuschnigg to hold a conference with Hitler, and Schuschnigg had indicated his willingness to do so. Acting under Hitler's instructions, von Papen then returned to Austria and arranged the conference which was held at Berchtesgaden on 12 February 1938. Von Papen accompanied Schuschnigg to that conference, and at its conclusion advised Schuschnigg to comply with Hitler's demands. On 10 March 1938, Hitler ordered von Papen to return to Berlin. Von Papen was in the Chancellery on 11 March, when the occupation of Austria was ordered. No evidence has been offered showing that von Papen was in favor of the decision to occupy Austria by force, and he has testified that he urged Hitler not to take this step. After the annexation of Austria, von Papen retired into private life, and there is no evidence that he took any part in politics. He accepted the position of ambassador to Turkey in April 1939, but no evidence has been offered concerning his activities in that position implicating him in crimes. The evidence leaves no doubt that von Papen's primary purpose as minister to Austria was to undermine the Schuschnigg regime and strengthen the Austrian Nazis for the purpose of bringing about Anschluss. To carry through this plan, he engaged in both intrigue and bullying. But the Charter does not make criminal such offenses against political morality, however bad these may be. Under the Charter, von Papen can be held guilty only if he was a party to the planning of aggressive war. There is no evidence that he was a party to the plans under which the occupation of Austria was a step in the direction of further aggressive action, or even that he participated in plans to occupy Austria by aggressive war if necessary. But it is not established beyond a reasonable doubt that this was the purpose of his activity, and therefore the tribunal cannot hold that he was a party to the common plan charged in Count 1, or participated in the planning of the aggressive wars charged in Count 2. Conclusion. The tribunal finds that von Papen is not guilty under this indictment, and directs that he shall be discharged by the Marshal when the tribunal presently adjourns. Seyss-Inquart. Seyss-Inquart is indicted under all 4 counts. Seyss-Inquart, an Austrian attorney, was appointed state councillor in Austria in May 1937 as a result of German pressure. He had been associated with the Austrian Nazi Party since 1931, but had often had difficulties with that party and did not actually join the Nazi Party until 13th March 1938. He was appointed Austrian Minister of Security and Interior, with control over the police, pursuant to one of the conditions which Hitler had imposed on Schuschnigg in the Berchtesgaden Conference of 12 February 1938. Activities in Austria. Seyss-Inquart participated in the last stages of the Nazi intrigue which preceded the German occupation of Austria, and was made Chancellor of Austria as a result of German threats of invasion. On 12 March 1938, Seyss-Inquart met Hitler at Linz and made a speech welcoming the German forces and advocating the reunion of Germany and Austria. On 13 March, he obtained the passage of a law providing that Austria should become a province of Germany, and succeeded Miklas as President of Austria when Miklas resigned rather than sign the law. Seyss-Inquart's title was changed to Reich Governor of Austria on 15 March 1938, and on the same day he was given the title of a general in the SS. He was made a Reich Minister without portfolio on 1 May 1939. On 11 March 1939, he visited the Slovakian cabinet in Bratislava and induced them to declare their independence in a way which fitted in closely with Hitler's offensive against the independence of Czechoslovakia. As Reich Governor of Austria, Seyss-Inquart instituted a program of confiscating Jewish property. Under his regime, Jews were forced to emigrate, were sent to concentration camps, and were subject to pogroms. At the end of his regime, he cooperated with the security police and SD in the deportation of Jews from Austria to the east. While he was governor of Austria, political opponents of the Nazis were sent to concentration camps by the Gestapo, mistreated and often killed. Criminal activities in Poland and the Netherlands. In September 1939, Seyss-Inquart was appointed Chief of Civil Administration of South Poland. On 12 October 1939, Seyss-Inquart was made Deputy Governor-General of the General Government of Poland under Frank. On 18 May 1940, Seyss-Inquart was appointed Reich Commissioner for Occupied Netherlands. In these positions, he assumed responsibility for governing territory which had been occupied by aggressive wars and the administration of which was of vital importance in the aggressive war being waged by Germany. As Deputy Governor-General of the General Government of Poland, Seyss-Inquart was a supporter of the harsh occupation policies which were put in effect. In November 1939, while on an inspection tour through the General Government, Seyss-Inquart stated that Poland was to be so administered as to exploit its economic resources for the benefit of Germany. Seyss-Inquart also advocated the persecution of Jews and was informed of the beginning of the AB action which involved the murder of many Polish intellectuals. As Reich Commissioner for the Occupied Netherlands, Seyss-Inquart was ruthless in applying terrorism to suppress all opposition to the German occupation, a program which he described as annihilating his opponents. In collaboration with the local higher SS and police leaders, he was involved in the shooting of hostages for offenses against the occupation authorities and sending to concentration camps all suspected opponents of occupation policies, including priests and educators. Many of the Dutch police were forced to participate in these programs by threats of reprisal against their families. Dutch courts were also forced to participate in this program, but when they indicated their reluctance to give sentences of imprisonment, because so many prisoners were in fact killed, a greater emphasis was placed on the use of summary police courts. Seyss-Inquart carried out the economic administration of the Netherlands without regard for the rules of the Hague Convention, which he described as obsolete. Instead, a policy was adopted for the maximum utilization of economic potential of the Netherlands, and executed with small regard for its effect on the inhabitants. There was widespread pillage of public and private property, which was given the color of legality by Seyss-Inquart's regulations, and assisted by manipulations of the financial institutions of the Netherlands under his control. As Reich Commissioner for the Netherlands, Seyss-Inquart immediately began sending forced laborers to Germany. Until 1942, labor service in Germany was theoretically voluntary, but was actually coerced by strong economic and governmental pressure. In 1942, Seyss-Inquart formally decreed compulsory labor service and utilized the services of the security police and SD to prevent evasion of his order. During the occupation, over 500,000 people were sent from the Netherlands to the Reich as laborers, and only a very small proportion were actually volunteers. One of Seyss-Inquart's first steps as Reich Commissioner of the Netherlands was to put into effect a series of laws imposing economic discriminations against the Jews. This was followed by decrees requiring their registration, decrees compelling them to reside in ghettos and to wear the Star of David, sporadic arrests and detention in concentration camps, and finally, at the suggestion of Heydrich, the mass deportation of almost 120,000 of Holland's 140,000 Jews to Auschwitz and the final solution. Seyss-Inquart admits knowing that they were going to Auschwitz, but claims that he had heard from people who had been to Auschwitz that the Jews were comparatively well off there, and that he thought that they were being held there for resettlement after the war. In light of the evidence, and on account of his official position, it is impossible to believe this claim. Seyss-Inquart contends that he was not responsible for many of the crimes committed in the occupation of the Netherlands because they were either ordered from the Reich, committed by the army over which he had no control, or by the German higher SS and police leader, who, he claims, reported directly to Himmler. It is true that some of the excesses were the responsibility of the army, and that the higher SS and police leader, although he was at the disposal of Seyss-Inquart, could always report directly to Himmler. It is also true that in certain cases Seyss-Inquart opposed the extreme measures used by these other agencies, as when he was largely successful in preventing the army from carrying out a scorched earth policy, and urged the higher SS and police leaders to reduce the number of hostages to be shot. But the fact remains that Seyss-Inquart was a knowing and voluntary participant in war crimes and crimes against humanity, which were committed in the occupation of the Netherlands. Conclusion. The Tribunal finds that Seyss-Inquart is guilty under counts 2, 3, and 4. Seyss-Inquart is not guilty on count 1. End of section 40. Recording by Maria Kasper.
Section 41 of Trial of the Major War Criminals, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Trial of the Major War Criminals before the International Military Tribunal, Nuremberg, 14th of November, 1945, through the 1st of October, 1946. Volume 1, by the International Military Tribunal. Judgment, Part 21. Speer. Speer is indicted under all 4 counts. Speer joined the Nazi Party in 1932. In 1934, he was made Hitler's architect and became a close personal confidant. Shortly thereafter, he was made a department head in the German Labor Front and the official in charge of capital construction, on the staff of the Deputy of the Führer, positions which he held through 1941. On the 15th of February 1942, after the death of Fritz Todt, Speer was appointed chief of the organization Todt and Reich Minister for Armaments and Munitions, after the 2nd of September 1943 for Armaments and War Production. The positions were supplemented by his appointments in March and April 1942 as General Plenipotentiary for Armaments and as a member of the Central Planning Board, both within the 4-year plan. Speer was a member of the Reichstag from 1941 until the end of the war. Crimes against peace. The tribunal is of opinion that Speer's activities did not amount to initiating, planning, or preparing wars of aggression, or of conspiring to that end. He became the head of the armament industry well after all of the wars had been commenced and were underway. His activities in charge of German armament production were in aid of the war effort, in the same way that other productive enterprises aid in the waging of war. But the tribunal is not prepared to find that such activities involve engaging in the common plan to wage aggressive war as charged under Count 1, or waging aggressive war as charged under Count 2. War crimes and crimes against humanity. The evidence introduced against Speer under Counts 3 and 4 relates entirely to his participation in the slave labor program. Speer himself had no direct administrative responsibility for this program, although he had advocated the appointment of a general plenipotentiary for the utilization of labor because he wanted one central authority with whom he could deal on labor matters. He did not obtain administrative control over Sauckel. Sauckel was appointed directly by Hitler under the decree of the 21st of March 1942, which provided that he should be directly responsible to Göring as plenipotentiary of the 4-year plan. As Reich Minister for Armaments and Munitions and General Plenipotentiary for Armaments under the 4-year plan, Speer had extensive authority over production. His original authority was over construction and production of arms for the OKW. This was progressively expanded to include naval armaments, civilian production, and finally, on the 1st of August 1944, air armament. As the dominant member of the Central Planning Board, which had supreme authority for the scheduling of German production and the allocation and development of raw materials, Speer took the position that the board had authority to instruct Sauckel to provide laborers for industries under its control, and succeeded in sustaining this position over the objection of Sauckel. The practice was developed under which Speer transmitted to Sauckel an estimate of the total number of workers needed. Sauckel obtained the labor and allocated it to the various industries in accordance with instructions supplied by Speer. Speer knew when he made his demands on Sauckel that they would be supplied by foreign laborers serving under compulsion. He participated in conferences involving the extension of the slave labor program for the purpose of satisfying his demands. He was present at a conference held during the 10th and 12th of August 1942 with Hitler and Sauckel, at which it was agreed that Sauckel should bring laborers by force from occupied territories, where this was necessary to satisfy the labor needs of the industries under Speer's control. Speer also attended a conference in Hitler's headquarters on the 4th of January 1944, at which the decision was made that Sauckel should obtain at least 4 million new workers from occupied territories in order to satisfy the demands for labor made by Speer, although Sauckel indicated that he could only do this with help from Himmler. Sauckel continually informed Speer and his representatives that foreign laborers were being obtained by force. At a meeting of the 1st of March 1944, Speer's deputy questioned Sauckel very closely about his failure to live up to the obligation to supply 4 million workers from occupied territories. In some cases, Speer demanded laborers from specific foreign countries. Thus, at the conference of the 10th through the 12th of August 1942, Sauckel was instructed to supply Speer with a further 1 million Russian laborers for the German armament industry up to and including October 1942. At a meeting of the Central Planning Board on the 22nd of April 1943, Speer discussed plans to obtain Russian laborers for use in the coal mines, and flatly vetoed the suggestion that this labor deficit should be made up by German labor. Speer has argued that he advocated the reorganization of the labor program to place a greater emphasis on utilization of German labor in war production in Germany and on the use of labor in occupied countries in local production of consumer goods formerly produced in Germany. Speer took steps in this direction by establishing the so-called blocked industries in the occupied territories, which were used to produce goods to be shipped to Germany. Employees of these industries were immune from deportation to Germany as slave laborers, and any worker who had been ordered to go to Germany could avoid deportation if he went to work for a blocked industry. This system, although somewhat less inhumane than deportation to Germany, was still illegal. The system of blocked industries played only a small part in the overall slave labor program, although Speer urged its cooperation with the slave labor program, knowing the way in which it was actually being administered. In an official sense, he was its principal beneficiary, and he constantly urged its extension. Speer was also directly involved in the utilization of forced labor as the chief of the organization Todt. The organization Todt functioned principally in the occupied areas on such projects as the Atlantic Wall and the construction of military highways, and Speer has admitted that he relied on compulsory service to keep it adequately staffed. He also used concentration camp labor in the industries under his control. He originally arranged to tap this source of labor for use in small out-of-the-way factories, and later, fearful of Himmler's jurisdictional ambitions, attempted to use as few concentration camp workers as possible. Speer was also involved in the use of prisoners of war in armament industries, but contends that he utilized Soviet prisoners of war only in industries covered by the Geneva Convention. Speer's position was such that he was not directly concerned with the cruelty in the administration of the slave labor program, although he was aware of its existence. For example, at meetings of the Central Planning Board, he was informed that his demands for labor were so large as to necessitate violent methods in recruiting. At a meeting of the Central Planning Board on the 30th of October, 1942, Speer voiced his opinion that many slave laborers who claimed to be sick were maligners, and stated, "There is nothing to be said against SS and police taking drastic steps and putting those known as slackers into concentration camps." Speer, however, insisted that the slave laborers be given adequate food and working conditions so that they could work efficiently. In mitigation, it must be recognized that Speer's establishment of blocked industries did keep many laborers in their homes, and that in the closing stages of the war, he was one of the few men who had the courage to tell Hitler that the war was lost and to take steps to prevent the senseless destruction of production facilities, both in occupied territories and in Germany. He carried out his opposition to Hitler's scorched earth program in some of the Western countries and in Germany by deliberately sabotaging it at considerable personal risk. Conclusion. The tribunal finds that Speer is not guilty on counts 1 and 2, but is guilty under counts 3 and 4. Von Neurath. Von Neurath is indicted under all 4 counts. He is a professional diplomat who served as German ambassador to Great Britain from 1930 to 1932. On the 2nd of June, 1932, he was appointed Minister of Foreign Affairs in the von Papen cabinet, a position which he held under the cabinets of von Schleicher and Hitler. Von Neurath resigned as Minister of Foreign Affairs on the 4th of February, 1938, and was made Reich Minister without portfolio, President of the Secret Cabinet Council, and a member of the Reich Defense Council. On the 18th of March, 1939, he was appointed Reich Protector for Bohemia and Moravia, and served in this capacity until the 27th of September, 1941. He held the formal rank of Obergruppenführer in the SS. Crimes against peace. As Minister of Foreign Affairs, Von Neurath advised Hitler, in connection with the withdrawal from the Disarmament Conference and the League of Nations on the 14th of October 1933, the institution of rearmament, the passage on the 16th of March 1935 of the law for universal military service, and the passage on the 21st of May 1935 of the secret Reich defense law. He was a key figure in the negotiation of the naval accord entered into between Germany and England on the 18th of June 1935. He played an important part in Hitler's decision to reoccupy the Rhineland on the 7th of March 1936 and predicted that the occupation could be carried through without any reprisals from the French. On the 18th of May 1936, he told the American ambassador to France that it was the policy of the German government to do nothing in foreign affairs until the Rhineland had been digested, and that as soon as the fortifications of the Rhineland had been constructed, and the countries of Central Europe realized that France could not enter Germany at will, all those countries will begin to feel very differently about their foreign policies and a new constellation will develop. Von Neurath took place in the Hossbach Conference of the 5th of November 1937. He has testified that he was so shocked by Hitler's statements that he had had a heart attack. Shortly thereafter, he offered to resign, and his resignation was accepted on the 4th of February 1938, at the same time that von Fritsch and von Blomberg were dismissed. Yet with knowledge of Hitler's aggressive plans, he retained a formal relationship with the Nazi regime as Reich Minister without portfolio, President of the Secret Cabinet Council, and a member of the Reich Defense Council. He took charge of the Foreign Office at the time of the occupation of Austria, assured the British ambassador that this had not been caused by a German ultimatum, and informed the Czechoslovakian minister that Germany intended to abide by its arbitration convention with Czechoslovakia. Von Neurath participated in the last phase of the negotiations preceding the Munich Pact, but contends that he entered these discussions only to urge Hitler to make every effort to settle the issues by peaceful means. Criminal activities in Czechoslovakia. Von Neurath was appointed Reich Protector for Bohemia and Moravia on the 18th of March 1939. Bohemia and Moravia were occupied by military force. Hacha's consent, obtained as it was by duress, cannot be considered as justifying the occupation. Hitler's decree of 16th of March 1939, establishing the Protectorate, stated that this new territory should belong henceforth to the territory of the German Reich, an assumption that the Republic of Czechoslovakia no longer existed. But it also went on the theory that Bohemia and Moravia retained their sovereignty, subject only to the interests of Germany, as expressed by the Protectorate. Therefore, even if the doctrine of subjugation should be considered to be applicable to territory occupied by aggressive action, the Tribunal does not believe that this proclamation amounted to an incorporation which was sufficient to bring the doctrine into effect. The occupation of Bohemia and Moravia must therefore be considered a military occupation covered by the rules of warfare. Although Czechoslovakia was not a party to the Hague Convention of 1907, the rules of land warfare expressed in this convention are declaratory of existing international law and hence are applicable. As Reich Protector, von Neurath instituted an administration in Bohemia and Moravia similar to that in effect in Germany. The free press, political parties, and trade unions were abolished. All groups which might serve as opposition were outlawed. Czechoslovakian industries were worked into the structure of German war production and exploited for the German war effort. Nazi anti-Semitic policies and laws were also introduced. Jews were barred from leading positions in government and business. In August 1939, von Neurath issued a proclamation warning against any acts of sabotage and stating that the responsibility of all acts of sabotage is attributed not only to individual perpetrators but to the entire Czech population. When the war broke out on the 1st of September 1939, 8,000 prominent Czechs were arrested by the security police in Bohemia and Moravia and put into protective custody. Many of this group died in concentration camps as a result of mistreatment. In October and November 1939, Czechoslovakian students held a series of demonstrations. As a result, on Hitler's orders, all universities were closed, 1,200 students imprisoned, and the 9 leaders of the demonstration shot by security police and SD. Von Neurath testified that he was not informed of this action in advance, but it was announced by proclamation over his signature, posted on placards throughout the Protectorate, which he claims, however, was done without his authority. On the 31st of August, 1940, von Neurath transmitted to Lammers a memorandum which he had prepared dealing with the future of the Protectorate, and a memorandum with his approval prepared by Karl Hermann Frank on the same subject. Both dealt with the question of Germanization and proposed that the majority of Czechs might be assimilated racially into the German nation. Both advocated the elimination of Czechoslovakian intelligentsia and other groups which might resist Germanization, von Neurath's by expulsion, Frank's by expulsion or special treatment. Von Neurath has argued that the actual enforcement of the repressive measures was carried out by the security police and SD, who were under the control of his state secretary, Karl Hermann Frank, who was appointed at the suggestion of Himmler, and who, as a higher SS and police leader, reported directly to Himmler. Von Neurath further argues that anti-Semitic measures and those resulting in economic exploitation were put into effect in the Protectorate as the result of policies decided upon in the Reich. However this may be, he served as the chief German official in the Protectorate when the administration of this territory played an important role in the wars of aggression which Germany was waging in the East, knowing that war crimes and crimes against humanity were being committed under his authority. In mitigation, it must be remembered that von Neurath did intervene with the security police and SD for the release of many of the Czechoslovaks who were arrested on the 1st of September 1939 and for the release of students arrested later in the fall. On the 23rd of September 1941, he was summoned before Hitler and told that he was not being harsh enough and that Heydrich was being sent to the Protectorate to combat the Czechoslovakian resistance groups. Von Neurath attempted to dissuade Hitler from sending Heydrich, but in vain, and when he was not successful, offered to resign. When his resignation was not accepted, he went on leave on the 27th of September 1941 and refused to act as protector after that date. His resignation was formally accepted in August 1943. Conclusion. The tribunal finds von Neurath is guilty under all 4 counts. End of section 41. Section 42 of Trial of the Major War Criminals, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Trial of the Major War Criminals before the International Military Tribunal, Nuremberg, 14th of November, 1945, through the 1st of October, 1946, Volume 1, by the International Military Tribunal. Judgment, Part 22. Fritzsche. Fritzsche is indicted on counts 1, 3, and 4. He was best known as a radio commentator, discussing once a week the events of the day on his own program, Hans Fritzsche Speaks. He began broadcasting in September 1932. In the same year, he was made head of the Wireless News Service, a Reich government agency. When, on the 1st of May 1933, this agency was incorporated by the National Socialists into their Reich Ministry of Popular Enlightenment and Propaganda, Fritzsche became a member of the Nazi Party and went to that ministry. In December 1938, he became the head of the Home Press Division of the ministry. In October 1942, he was promoted to the rank of Ministerial Director. After serving briefly on the Eastern Front in a propaganda company, he was, in November 1942, made head of the radio division of the propaganda ministry and plenipotentiary for the political organization of the Greater German Radio. Crimes against peace. As head of the Home Press Division, Fritzsche supervised the German press of 2,300 daily newspapers. In pursuance of this function, he held daily press conferences to deliver the directives of the propaganda ministry to these papers. He was, however, subordinate to Dietrich, the Reich press chief, who was in turn a subordinate of Goebbels. It was Dietrich who received the directives to the press of Goebbels and other Reich ministers and prepared them as instructions, which he then handed to Fritzsche for the press. From time to time, the daily paroles of the Reich press chief, as these instructions were labeled, directed the press to present to the people certain themes, such as the leadership principle, the Jewish problem, the problem of living space, or other standard Nazi ideas. A vigorous propaganda campaign was carried out before each major act of aggression. While Fritzsche headed the Home Press Division, he instructed the press how the actions or wars against Bohemia and Moravia, Poland, Yugoslavia, and the Soviet Union should be dealt with. Fritzsche had no control of the formulation of these propaganda policies. He was merely a conduit to the press of the instructions handed him by Dietrich. In February 1939, and before the absorption of Bohemia and Moravia, for instance, he received Dietrich's order to bring to the attention of the press Slovakia's efforts for independence and the anti-Germanic policies and politics of the existing Prague government. This order to Dietrich originated in the Foreign Office. The Radio Division, of which Fritzsche became the head in November 1942, was one of the 12 divisions of the propaganda ministry. In the beginning, Dietrich and other heads of divisions exerted influence over the policies to be followed by radio. Towards the end of the war, however, Fritzsche became the sole authority within the ministry for radio activities. In this capacity, he formulated and issued daily radio paroles to all Reich propaganda offices according to the general political policies of the Nazi regime, subject to the directives of the Radio Political Division of the Foreign Office and the personal supervision of Goebbels. Fritzsche, with other officials of the propaganda ministry, was present at Goebbels' daily staff conferences. Here they were instructed in the news and propaganda policies of the day. After 1943, Fritzsche himself occasionally held these conferences, but only when Goebbels and his state secretaries were absent. And even then, his only function was to transmit the Goebbels directives relayed to him by phone. This is the summary of Fritzsche's positions and influence in the Third Reich. Never did he achieve sufficient stature to attend the planning conferences which led to aggressive war. Indeed, according to his own uncontradicted testimony, he never even had a conversation with Hitler. Nor is there any showing that he was informed of the decisions taken at these conferences. His activities cannot be said to be those which fall within the definition of the common plan to wage aggressive war as already set forth in this judgment. War crimes and crimes against humanity. The prosecution has asserted that Fritzsche incited and encouraged the commission of war crimes by deliberately falsifying news to arouse in the German people those passions which led them to the commission of atrocities under counts 3 and 4. His position and official duties were not sufficiently important, however, to infer that he took part in originating or formulating propaganda campaigns. Excerpts in evidence from his speeches show definite anti-Semitism on his part. He broadcast, for example, that the war had been caused by Jews and said their fate had turned out as unpleasant as the Führer predicted. But these speeches did not urge persecution or extermination of Jews. There is no evidence that he was aware of their extermination in the East. The evidence, moreover, shows that he twice attempted to have publication of the anti-Semitic Der Stürmer suppressed, though unsuccessfully. In these broadcasts, Fritzsche sometimes spread false news, but it was not proved he knew it to be false. For example, he reported that no German U-boat was in the vicinity of the Athenia when it was sunk. This information was untrue, but Fritzsche, having received it from the German Navy, had no reason to believe it was untrue. It appears that Fritzsche sometimes made strong statements of a propagandistic nature in his broadcasts, but the Tribunal is not prepared to hold that they were intended to incite the German people to commit atrocities on conquered peoples, and he cannot be held to have been a participant in the crimes charged. His aim was rather to rouse popular sentiment in support of Hitler and the German war effort. Conclusion. The Tribunal finds that Fritzsche is not guilty under this indictment, and directs that he shall be discharged by the Marshal when the Tribunal presently adjourns. Bormann. Bormann is indicted on counts 1, 3, and 4. He joined the National Socialist Party in 1925, was a member of the staff of the Supreme Command of the SA from 1928 to 1930, was in charge of the aid fund of the party, and was Reichsleiter from 1933 to 1945. From 1933 to 1941, he was Chief of Staff in the office of the Führer's deputy, and, after the flight of Hess to England, became head of the party chancellery on the 12th of May, 1941. On the 12th of April, 1943, he became secretary to the Führer. He was political and organizational head of the Volkssturm and a general in the SS. Crimes against peace. Bormann, in the beginning a minor Nazi, steadily rose to a position of power, and, particularly in the closing days, of great influence over Hitler. He was active in the party's rise to power, and even more so in the consolidation of that power. He devoted much of his time to the persecution of the churches and of the Jews within Germany. The evidence does not show that Bormann knew of Hitler's plan to prepare, initiate, or wage aggressive wars. He attended none of the important conferences when Hitler revealed piece by piece these plans for aggression. Nor can knowledge be conclusively inferred from the positions he held. It was only when he became head of the party chancellery in 1941, and later in 1943 secretary to the Führer, when he attended many of Hitler's conferences, that his positions gave him the necessary access. Under the view stated elsewhere, which the Tribunal has taken, of the conspiracy to wage aggressive war, there is not sufficient evidence to bring Bormann within the scope of count 1. War crimes and crimes against humanity. By decree of the 29th of May, 1941, Bormann took over the offices and powers held by Hess. By the decree of the 24th of January, 1942, these powers were extended to give him control over all laws and directives issued by Hitler. He was thus responsible for laws and orders issued thereafter. On the 1st of December, 1942, all Gaue became Reich Defense districts, and the party Gauleiters, responsible to Bormann, were appointed Reich Defense Commissioners. In effect, this made them the administrators of the entire civilian war effort. This was so not only in Germany, but also in those territories which were incorporated into the Reich from the absorbed and conquered territories. Through this mechanism, Bormann controlled the ruthless exploitations of the subjected populace. His order of the 12th of August, 1942, placed all party agencies at the disposal of Himmler's program for the forced resettlement and denationalization of persons in the occupied countries. 3 weeks after the invasion of Russia, he attended the conference of the 16th of July, 1941, at Hitler's field quarters with Göring, Rosenberg, and Keitel. Bormann's reports show that there were discussed and developed detailed plans of enslavement and annihilation of the population of these territories. On the 8th of May, 1942, he conferred with Hitler and Rosenberg on the forced resettlement of Dutch personnel in Latvia, the extermination program in Russia, and the economic exploitation of the Eastern Territories. He was interested in the confiscation of art and other properties in the East. His letter of the 11th of January, 1944, called for the creation of a large-scale organization to withdraw commodities from the occupied territories for the bombed-out German populace. Bormann was extremely active in the persecution of the Jews, not only in Germany, but also in the absorbed and conquered countries. He took part in the discussions which led to the removal of 60,000 Jews from Vienna to Poland in cooperation with the SS and the Gestapo. He signed the decree of the 31st of May, 1941, extending the Nuremberg laws to the annexed Eastern territories. In an order of the 9th of October, 1942, he declared that the permanent elimination of Jews in Greater German territory could no longer be solved by emigration, but only by applying ruthless force in the special camps in the East. On the 1st of July, 1943, he signed an ordinance withdrawing Jews from the protection of the law courts and placing them under the exclusive jurisdiction of Himmler's Gestapo. Bormann was prominent in the slave labor program. The party leaders supervised slave labor matters in the respective Gaue, including employment, conditions of work, feeding, and housing. By his circular of the 5th of May, 1943, to the Leadership Corps, distributed down to the level of Ortsgruppenleiter, he issued directions regulating the treatment of foreign workers, pointing out they were subject to SS control on security problems, and ordered the previous mistreatment to cease. A report of the 4th of September, 1942, relating to the transfer of 500,000 female domestic workers from the East to Germany, showed that control was to be exercised by Sauckel, Himmler, and Bormann. Sauckel, by decree of the 8th of September, directed the Kreisleiter to supervise the distribution and assignment of these female laborers. Bormann also issued a series of orders to the party leaders dealing with the treatment of prisoners of war. On the 5th of November, 1941, he prohibited decent burials for Russian prisoners of war. On the 25th of November, 1943, he directed Gauleiter to report cases of lenient treatment of prisoners of war. On the 13th of September, 1944, he ordered liaison between the Kreisleiter with the camp commandants in determining the use to be made of prisoners of war for forced labor. On the 29th of January, 1943, he transmitted to his leaders OKW instructions allowing the use of firearms and corporal punishment on recalcitrant prisoners of war, contrary to the rules of land warfare. On the 30th of September, 1944, he signed a decree taking from the OKW jurisdiction over prisoners of war and handing them over to Himmler and the SS. Bormann is responsible for the lynching of Allied airmen. On the 30th of May, 1944, he prohibited any police action or criminal proceedings against persons who had taken part in the lynching of Allied flyers. This was accompanied by a Goebbels propaganda campaign inciting the German people to take action of this nature, and the conference of the 6th of June, 1944, where regulations for the application of lynching were discussed. His counsel, who has labored under difficulties, was unable to refute this evidence. In the face of these documents, which bear Bormann's signature, it is difficult to see how he could do so even were the defendant present. Counsel has argued that Bormann is dead and that the tribunal should not avail itself of Article 12 of the Charter, which gives it the right to take proceedings in absentia. But the evidence of death is not conclusive, and the tribunal, as previously stated, is determined to try him in absentia. If Bormann is not dead and is later apprehended, the Control Council for Germany may, under Article 29 of the Charter, consider any facts in mitigation and alter or reduce his sentence if deemed proper. Conclusion. The tribunal finds that Bormann is not guilty on count 1, but is guilty on counts 3 and 4. The 1st of October, 1946. Signed Jeffrey Lawrence, President. Signed Norman Burkett. Signed Francis Biddle. Signed John J. Parker. Signed H. Donadieu de Vabre. Signed R. Falco. Signed Nikitchenko. Signed A. Volkov. End of section 42. Section 43 of Trial of the Major War Criminals, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Trial of the Major War Criminals before the International Military Tribunal, Nuremberg, 14th of November, 1945 through the 1st of October, 1946, Volume 1, by the International Military Tribunal. Dissenting Opinion, Part 1. Dissenting opinion of the Soviet member of the International Military Tribunal. The tribunal decided: A. To acquit the defendants Hjalmar Schacht, Franz von Papen, and Franz Fritzsche. B. To sentence the defendant Rudolf Hess to life imprisonment. C. Not to declare criminal the following organizations: the Reichscabinet, General Staff, and OKW. In this respect, I cannot agree with the decision adopted by the tribunal, as it does not correspond to the facts of the case and is based on incorrect conclusions. 1. The unfounded acquittal of defendant Schacht. The evidence submitted to the tribunal in the case of Schacht confirms the following facts. A. Schacht established contact with Göring in December 1930 and with Hitler at the beginning of 1931. He subsequently established contact between the leadership of the Nazi Party and the foremost representatives of the German industrial and financial circles. This in particular is confirmed by the testimony of witness Severing. Transcript, afternoon session, the 23rd of May, 1946, USA 615. B. In July 1932, Schacht demanded that von Papen resign his post as Reich Chancellor in favor of Hitler. This fact is confirmed by von Papen's testimony at the preliminary interrogation and by Schacht's own testimony in court. Transcript, afternoon session, 2nd of May, 1946. C. In November 1932, Schacht collected signatures of German industrialists, urging them to come out for Hitler's appointment as Reich Chancellor. On the 12th of November 1932, Schacht wrote to Hitler, "I have no doubt that the way we are directing the course of events can only lead to your appointment as Reich Chancellor. We are trying to secure a large number of signatures among the industrial circles to ensure your appointment to this post." EC 456, USA 773, PS 3901, USA 837. D. In February 1933, Schacht organized the financing of the pre-election campaign conducted by the Nazi Party and demanded at the conference of Hitler and Göring with the industrialists that the latter provide 3 million marks, D 203. Schacht admitted in court that he had pointed out the necessity for providing the Nazi leaders with this sum. Transcript, afternoon session, 3rd of May, 1946. While the defendant Funk and the former member of the management of IG Farben Industrie, Schindler, who was present at this conference, both confirmed that it was Schacht who was the initiator of the financing of the pre-election campaign. Transcript, 4th of July, 1946, EC 439, USA 618. E. Utilizing his prestige, Schacht also repeatedly admitted in his public statements that he asked for the support in the elections of both the Nazi Party and of Hitler. USA 615, USA 616. Transcript, afternoon session, 2nd of May, 1946. On the 29th of August, 1932, Schacht wrote to Hitler, "No matter where my activities lead me in the near future, even if someday you see me imprisoned in a fortress, you can always depend on me as your loyal aide." EC 457, USA 619. Thus Schacht consciously and deliberately supported the Nazi Party and actively aided in the seizure of power in Germany by the fascists. Even prior to his appointment as plenipotentiary for war economy, and immediately after the seizure of power by the Nazis, Schacht led in planning and developing the German armaments as follows. A. On the 17th of March, 1933, Schacht was appointed president of the Reichsbank. PS 3021, USA 11. And as he himself stated in a speech before his Reichsbank colleagues on the 21st of March 1938, the Reichsbank under his management was none other than a National Socialist institution. Transcript, afternoon session, 3rd of May 1946. B. In August 1934, Schacht was appointed Reich Minister of Economy. PS 3021, USA 11. His ministry was given the task of carrying out the economic preparation for war. EC 128, USA 623. A special decree granted Schacht, in his capacity of Reich Minister of Economy, unlimited authority in the field of economy. Reichsgesetzblatt, 1934, Part 1, page 565. C. Making use of these powers in 1934, Schacht launched upon the execution of the new program developed by him. Reichsgesetzblatt, 1934, Part 1, page 826. And, as Schacht himself noted in his speech of the 29th of November, 1938, this organization played a tremendous part in the course of Germany's rearmament. EC 611, USA 662. D. For the purpose of the most effective execution of this new program, Schacht used the property and means of those political enemies of the Nazi regime who either became the victims of terror or were forced to emigrate. Schacht's note to Hitler of the 3rd of May 1939. PS 1168, USA 37. Schacht used swindlers' tactics and coercion in an effort to acquire raw material and foreign currency for armaments. Affidavit of Vice President of the Reichsbank, Poll, EC 437, USA 624. E. During the first days of his association with the Reichsbank, Schacht issued a series of decrees. 27th of October 1933, 23rd of March 1934, 19th of February 1935, which in the long run helped realize the broad program of the financing of armaments developed by him, and with the aid of which, as he testified, he had found the way to finance the rearmament program. In his speech in Leipzig on the 4th of March 1935, Schacht, while summing up his preceding economic and financial activities, announced, "Everything that I say and do has the Führer's full agreement, and I shall not do or say anything which is not approved by the Führer." Transcript, afternoon session, 3rd of May 1946. Having become plenipotentiary general for war economy, Schacht unified under himself the leadership of the entire German economy, and through his efforts, the establishment of the Hitlerite war machine was accomplished. A. The secret law of the 21st of May 1935, which appointed Schacht the plenipotentiary general for war economy, states as follows. The task of the plenipotentiary general for war economy is to place all the economic resources in the service of warfare. The plenipotentiary general for war economy, within the framework of his functions, is given the right to issue legal orders deviating from the existing laws. He is the responsible head for financing wars through the Reich Ministry and the Reichsbank. PS 2261, USA 24. B. Schacht financed German armaments through the Mefo system of promissory notes, which was a swindling venture on a national scale that has no precedent, and the success of which was dependent upon the realization of the aggressive plans of the Hitlerites. It was because of this that Schacht set 1942 as the date when the Mefo notes were to mature, and he pointed out in his speech of the 29th of November 1938 the relation between the daring credit policy of the Reichsbank and the aims of the Hitlerite foreign policy. EC 611, USA 622. C. Having made full use of his plenary powers, Schacht carefully developed and carried out a broad plan of economic mobilization which allowed the Hitlerite leaders to wage war at any time considered most favorable. In particular, from the report of Schacht's deputy, Wohltat, the preparation for mobilization carried out by the plenipotentiary for war economy shows that Schacht provided the last detail for the system of exploitation of the German economy in wartime, all the way from the utilization of industrial enterprises, of raw material resources and manpower, down to the distribution of 80 million ration cards. EC 258, USA 625. It is significant that this report was drawn up a month after Hitler's statement at the conference of the 5th of November 1937, at which Hitler set forth this concrete plan of aggression. PS 386, USA 25. Summarizing his past activity, Schacht wrote in January 1937, "I worked out the preparation for war in accordance with the principle that the plan of our war economy must be built in peacetime in such a way that there will be no necessity for any reorganization in case of war." Schacht confirmed his statement in court. Transcript, afternoon session, the 2nd of May, 1946. Schacht consciously and deliberately prepared Germany for war. D. The former Minister of War von Blomberg testified that Schacht was fully cognizant of the plans for development and increase of the German armed forces, since he was constantly informed of all the financing necessary for the development of the German armed forces. USA 838. On the 31st of August 1936, von Blomberg informed Schacht that the establishment of all the Air Force units must be completed by the 1st of April 1937, and therefore large expenditures must be entailed in 1936. PS 1301, USA 123. In the spring of 1937, Schacht participated in the military exercises in Godesberg. EC 174. E. In his memorandum to Hitler on the 3rd of May 1935, entitled "The Financing of Rearmament," Schacht wrote, "A speedy fulfillment of the program for rearmament on a mass scale is the basis of German policy, and therefore everything else must be subordinate to this task. The completion of this task, the achievement of this purpose, must meet no obstacles." PS 1168, USA 37. In his speech on the 29th of November 1938, Schacht announced that Reichsbank credit policy made it possible for Germany to create an unsurpassed machine, and in turn, this war machine made possible the realization of the aims of our policy. EC 611, USA 622. One must exclude the supposition that Schacht was not informed as to what purposes these weapons were to serve, since he could not but take into consideration their unprecedented scale and an obvious preference for offensive types of weapons, heavy tanks, bombers, and so on. Besides, Schacht knew perfectly well that not a single country intended to wage war on Germany, nor had any reasons to do so. A. Schacht utilized the military might growing under his direction to back Germany's territorial demands, which grew in proportion to the increase in armaments. Schacht testified in court that at first he confined himself in his demands to the colonies which once belonged to Germany. Transcript, morning session, 3rd of May, 1946. In September 1934, during his talk with the American ambassador Dodd, Schacht pointed out that he desired annexation if possible without war, but through war if the United States would stay out of it. EC 461, USA 58. In 1935, Schacht announced to the American consul, Fuller, "Colonies are essential to Germany. If it is possible, we shall acquire them through negotiations. If not, we shall seize them." EC 450, USA 629. Schacht admitted in court that military pressure put upon Czechoslovakia was in some measure the result and the fruit of his labor. Transcript, Morning Session, 3rd of May, 1946. B. Schacht personally participated in the plunder of private and state property of the countries which became victims of Hitlerite aggressions. The minutes of the conference of the Military Economic Staff on the 11th of March, 1938, in which Schacht participated, state that those present were given Hitler's latest directives about the invasion of Austria. Further, the minutes state, "After this, at the suggestion of Schacht, it was decided that all the financial accounting will be made in Reichsmarks at the rate of exchange, 2 shillings for 1 Reichsmark." EC 421, USA 645. Schacht admitted in court that he personally was in charge of the seizure of the Czechoslovak National Bank after the occupation of Czechoslovakia. Transcript, Morning Session, 3rd of May, 1946. C. At the beginning of 1940, Schacht offered Hitler his services for negotiations with the United States in regard to the discontinuance of aid to England, and he informed Göring of his offer. PS 3700, USA 780. D. Schacht considered it his duty to greet and congratulate Hitler publicly after the signing of armistice with France, although Schacht, better than anyone else, understood the usurpatory nature of the armistice. German documentary film, USA 635. E. In his letter to Funk on the 17th of October 1941, Schacht suggested a more effective exploitation of occupied territory. In this case, too, Schacht acted on his own initiative. EC 503, USA 830. Schacht also participated in the persecution of the Jews. A. He testified in court that he agreed to the policy of the persecution of the Jews as a matter of principle. Transcript, Afternoon Session, 2nd of May, 1946. Although, he stated, to a certain extent, it was a matter of conscience which, however, was not serious enough to bring about a break between him and the Nazis. Transcript, Afternoon Session, the 2nd of May, 1946. USA 616. B. In his capacity of Minister of Economy, Schacht signed a series of decrees, in accordance with which the property of the Jews in Germany was subject to plunder with impunity. USA 832, USA 616. Schacht confirmed in court the fact that he had signed a series of anti-Semitic decrees. Transcript, Afternoon Session, the 2nd of May, 1946. As to the reasons for Schacht's resignation from the post of the Minister of Economy and the Plenipotentiary General for War Economy in November 1937, and also from the post of the President of the Reichsbank on the 20th of November 1939, and finally from the post of the Minister without Portfolio in January 1943, the evidence submitted establishes the following. A. The reason is not Schacht's disagreement with the economic preparation for aggressive wars. 3 weeks before leaving the Ministry of Economy and the post of Plenipotentiary General for War Economy, Schacht wrote to Göring, "I also don't consider that my opinion can differ from yours on economic policy." EC 497, USA 775. In his reply, Göring states, "You promised me your support and collaboration. You have repeated this promise many times, even after differences of opinion began to creep up between us." EC 493, USA 642. Schacht testified in court that Göring and he only differed in matters of procedure. Transcript, morning session, 3rd of May, 1946. In the preliminary examination, Göring testified that Schacht's leaving the Reichsbank had no relation to the program of rearmament. USA 648. The vice president of the Reichsbank, Pohl, confirmed that Schacht's resignation from the Reichsbank can be explained by his desire to extricate himself from a dangerous situation, which developed as the result of Schacht's own crooked financial operations. EC 438, USA 646. B. The reason is not Schacht's disapproval of mass terror conducted by the Hitlerites. The witness for the defense, Gisevius, testified that he constantly informed Schacht of the criminal actions of the Gestapo created by Göring, and that nevertheless, right up to the end of 1936, Schacht looked for Göring's support. Transcript, morning session, 24th of April, 1946. In his letter to von Blomberg on the 24th of December, 1935, Schacht suggested that the Gestapo apply more cautious methods, since the open terror of the Gestapo hinders the objectives of the armament. Transcript, afternoon session, 2nd of May, 1946. On the 30th of January, 1937, Schacht was awarded a Golden Party insignia by Hitler. EC 500. Transcript, afternoon session, 2nd of May, 1946. As stated in an official German publication, he was able to be of greater help to the party if he were actually a member of the party. EC 460, USA 617. Only in 1943, having understood earlier than many other Germans the inevitability of the failure of the Hitlerite regime, did Schacht establish contact with the opposition circles, however, doing nothing to help depose this regime. Therefore, it was not by chance that, having found out these connections of Schacht, Hitler still spared Schacht's life. It is thus indisputably established that a. Schacht actively assisted in the seizure of power by the Nazis. b. During a period of 12 years, Schacht closely collaborated with Hitler. c. Schacht provided the economic and financial basis for the creation of the Hitlerite military machine. d. Schacht prepared Germany's economy for the waging of aggressive wars. e. Schacht participated in the persecution of Jews and in the plunder of territories occupied by the Germans. Therefore, Schacht's leading part in the preparation and execution of the common criminal plan is proved. The decision to acquit Schacht is in obvious contradiction with existing evidence. 2. The unfounded acquittal of defendant von Papen. The verdict does not dispute the fact that von Papen prepared the way for Hitler's appointment to the post of the Reich Chancellor, and that he actively helped the Nazis in their seizure of power. In a speech of November 1933, von Papen said the following on the subject. Just as I, at the time of taking over the chancellorship, this was in 1932, have advocated to pave the way to power for the young fighting liberation movement, just as I, on the 30th of January, was selected by a gracious fate to put the hands of our Chancellor and Führer into the hands of our beloved Field Marshal, so do I today again feel the obligation to say to the German people and all those who have kept confidence in me, the kind Lord has blessed Germany by giving it in times of deep distress a leader. PS 3375. It was von Papen who revoked Brüning's order dissolving the SS and the SA, thus allowing the Nazis to realize their program of mass terror. D. 631. Again, it was the defendant who, by the application of brute force, did away with the social democratic government of Braun and Severing. Severing's testimony, transcript, afternoon session, 4th of June, 1946. On the 4th of January, 1933, von Papen had a conference with Hitler, Hess, and Himmler. D. 632. Von Papen participated in the purge of the state machinery of all personnel considered unreliable from the Nazi point of view. On the 21st of March 1933, he signed a decree creating special political tribunals. He had also signed an order granting amnesty to criminals whose crimes were committed in the course of the National Revolution. He participated in drafting the text of the order, ensuring party and state unity, and so on. Subsequently, Von Papen faithfully served the Hitler regime. After the Putsch of 1934, Von Papen ordered his subordinate, Terziski, to appear in the Gestapo, knowing full well what awaited him there. D. 684. Von Papen helped to keep the bloody murder secret from public opinion. D. 717. D. 718. The defendant played a tremendous role in helping Nazis to take possession of Austria. 3 weeks after the assassination of Dollfuss, on the 26th of July, 1934, Hitler told Von Papen that he was being appointed minister to Vienna, especially noting in a letter, "You have been and continue to be in possession of my fullest and most unlimited trust." PS 2799. In this connection, it is impossible to ignore the testimony of the American ambassador, Messerschmitt, who quoted Von Papen as saying that the seizure of Austria is only the first step, and that he, Von Papen, was in Austria for the purpose of further weakening the Austrian government. USA 57. The defendant was Hitler's chief advisor in effecting plans for the seizure of Austria. It was he who proposed several tactical maneuvers to quiet the vigilance of world opinion on the one hand and allow Germany to conclude her war preparations on the other. This follows indisputably from Von Papen's statement to the Austrian minister Birger Waldeneck, PS 1760, from the report of Geleiter Runer on the 6th of July 1939, USA 61. From Von Papen's report to Hitler of the 21st of August 1936, D 706. From Von Papen's report to Hitler of the 1st of September 1936, PS 2246, USA 67. And from a series of other documents which have been submitted in evidence. Von Papen played this game until the issuance of the order for alerting the German armed forces for moving into Austria. He participated in arranging the conference between Hitler and Schuschnigg on the 12th of February 1938. USA 69. It was Von Papen who, in a letter to Hitler, emphatically recommended that financial aid be given the Nazi organization in Austria known as the Freedom Union, specifically for its fight against the Jewry. PS 2830. Indisputable appears the fact of the Nazi seizure of Austria and of Von Papen's participation in this act of aggression. After the occupation of Austria, Hitler rewarded Von Papen with the golden insignia of the Nazi Party. D 632. Neither is it possible to ignore Von Papen's role as agent provocateur when in his capacity of diplomat he was the German ambassador to Turkey, whenever evaluation of his activity there is made. The post of ambassador to Turkey was at the time of considerable importance in helping the Nazis realize their aggressive plans. The official Nazi biographer wrote about Von Papen as follows. Shortly after the occupation of Austria, the Führer had need of Von Papen's services again, and on the 18th of April, 1939, he therefore appointed him German ambassador in Ankara. D 632. It should also be noted that for his Turkish activities, Hitler rewarded Von Papen with the Knight's Cross of the War Merit Order with swords. D 632. Thus, evidence submitted establishes beyond doubt that A. Von Papen actively aided the Nazis in their seizure of power. B. Von Papen used both his efforts and his connections to solidify and strengthen the Hitlerian terroristic regime in Germany. C. Von Papen actively participated in the Nazi aggression against Austria, culminating in its occupation. D. Von Papen faithfully served Hitler up to the very end, aiding the Nazi plans of aggression, both with his ability and his diplomatic skill. It therefore follows that defendant Von Papen bears considerable responsibility for the crimes of the Hitlerite regime. For these reasons, I cannot consent to the acquittal of defendant Von Papen. 3. The unfounded acquittal of defendant Fritzsche. The acquittal of defendant Hans Fritzsche follows from the reasoning that Fritzsche, allegedly, had not reached in Germany the official position making him responsible for the criminal actions of the Hitler regime, and that his own personal activity in this respect cannot be considered criminal. The verdict characterizes him as a secondary figure carrying out the directives of Goebbels and von Ribbentrop and of the Reich Press director Dietrich. The verdict does not take into consideration or mention the fact that it was Fritzsche who until 1942 was the director de facto of the Reich Press, and that according to himself, subsequent to 1942, he became the commander-in-chief of the German radio. Transcript, Morning Session, 23rd of January, 1946. For the correct definition of the role of defendant Hans Fritzsche, it is necessary, firstly, to keep clearly in mind the importance attached by Hitler and his closest associates, as Göring, for example, to propaganda in general and to radio propaganda in particular. This was considered one of the most important and essential factors in the success of conducting an aggressive war. In the Germany of Hitler, propaganda was invariably a factor in preparing and conducting acts of aggression and in training the German populace to accept obediently the criminal enterprises of German fascism. The aim of these enterprises was served by a huge and well centralized propaganda machinery. With the help of the police controls and of a system of censorship, it was possible to do away altogether with the freedom of press and of speech. The basic method of the Nazi propagandist activity lay in the false presentation of facts. This is stated quite frankly in Hitler's Mein Kampf. With the help of a skillful and continuous application of propaganda, it is possible to make the people conceive even of heaven as hell, and also make them consider heavenly the most miserable existence. USA 276. The dissemination of provocative lies and the systematic deception of public opinion were as necessary to the Hitlerites for the realization of their plans as were the production of armaments and the drafting of military plans. Without propaganda, founded on the total eclipse of the freedom of press and of speech, it would not have been possible for German fascism to realize its aggressive intentions, to lay the groundwork, and then to put to practice the war crimes and the crimes against humanity. In the propaganda system of the Hitler state, it was the daily press and the radio that were the most important weapons. In his court testimony, defendant Göring named 3 factors as essential in the successful conduct of modern war according to the Nazi concept, namely: 1. The military operations of the armed forces. 2. Economic warfare. 3. Propaganda. With reference to the latter, he said, "For what great importance the war of propaganda had, enemy propaganda, which extended by way of radio far into the hinterland, no one has experienced more strongly than Germany." Transcript, Afternoon Session, 15th of March, 1946. With such concepts in ascendance, it is impossible to suppose that the supreme rulers of the Reich would appoint to the post of the director of radio propaganda, who supervised radio activity of all the broadcasting companies and directed their propagandist content, a man they considered a secondary figure. The point of view of the verdict contradicts both the evidence submitted and the actual state of affairs. Beginning in 1942 and into 1945, Fritzsche was not only chief of the radio department of the Reich Ministry of Propaganda, but also plenipotentiary for the political organization of radio in Greater Germany. This circumstance is fully proved by the sworn affidavit of Fritzsche himself. PS 3469, USA 721. It thus follows that not at all was Fritzsche merely one of the 12 departmental chiefs in the Ministry of Propaganda, who acquired responsibility for all radio propaganda only toward the end of the war, as the verdict asserts. Fritzsche was the political director of the German radio up and into 1945, for example, up to the moment of German defeat and capitulation. For this reason, it is Fritzsche who bears responsibility for the false and provocative broadcasts of the German radio during the years of the war. As chief of the press section inside Germany, it was also Fritzsche who was responsible for the activity of the German daily press, consisting of 2,300 newspapers. It was Fritzsche who created and perfected the information section, winning from the Reich government for the purpose an increase in the subsidy granted the newspapers from 400,000 to 4,000,000 marks. Subsequently, Fritzsche participated energetically in the development of the propaganda campaigns preparatory to the acts of aggression against Czechoslovakia and Poland. Transcript, Morning Session, 23 January 1946. A similar active propaganda campaign was conducted by the defendant prior to the attack on Yugoslavia, as he himself admitted on oath in court. Transcript, Morning Session, 23 January 1946. Fritzsche was informed of the plan to attack the Soviet Union and was made au courant of the military intentions at a conference with Rosenberg. PS 1039, USA 146. Rosenberg's written report to Hitler on the subject of preliminary work in Eastern European questions. Fritzsche headed the German press campaign, falsifying reports of Germany's aggressive war against France, England, Norway, the Soviet Union, the United States, and the other states. The assertion that Fritzsche was not informed of the war crimes and the crimes against humanity then being perpetrated by the Hitlerites in the occupied regions does not agree with the facts. From Fritzsche's testimony in court, it is obvious that already in May 1942, while in the propaganda section of the Sixth Army, he was aware of Hitler's decree ordering execution for all Soviet political workers and Soviet intellectuals, the so-called Commissar Decree. Transcript, Afternoon Session, 27 June 1946. It is also established that already at the beginning of hostilities, Fritzsche was fully aware of the fact that the Nazis were carrying out their decision to do away with all Jews in Europe. For instance, when commenting on Hitler's statement that among results of the war there will be the annihilation of the Jewish race in Europe. Transcript, Afternoon Session, the 22nd of November, 1945. Fritzsche stated that, as the Führer predicted it would occur in the event of war in Europe, the fate of the European Jewry turned out to be quite sad. Transcript, Morning Session, the 23rd of January, 1946. It is further established that the defendant systematically preached the antisocial theory of race hatred and characterized peoples inhabiting countries victimized by aggression as subhumans. Transcript, Afternoon Session, the 27th of June, 1946. Transcript, Morning Session, the 28th of June, 1946. When the fate of Nazi Germany became clear, Fritzsche came out with energetic support of the defendant Martin Bormann and of other fanatical Hitler adherents who organized the undercover fascist association, the so-called Werewolf. On the 7th of April, 1945, for example, in his last radio address, Fritzsche agitated for all the civilian population of Germany to take active part in the activities of this terroristic Nazi underground organization. He said, "Let no one be surprised to find the civilian population wearing civilian clothes, still continuing the fight in the regions already occupied and even after occupation has taken place. We shall call this phenomenon werewolf, since it will have arisen without any preliminary planning and without a definite organization, out of the very instinct of life." USSR 496. In his radio addresses, Fritzsche welcomed the German use of the new terror weapons in conducting the war, specifically the use of the V rockets. On receiving a plan for the introduction of bacterial warfare, he immediately forwarded it to the OKW for acceptance. USSR 484. Evidence submitted during the afternoon session, the 28th of June, 1946. I consider Fritzsche's responsibility fully proven. His activity had a most basic relation to the preparation and the conduct of aggressive warfare, as well as to the other crimes of the Hitler regime. End of section 43. Section 44 of Trial of the Major War Criminals, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Trial of the Major War Criminals before the International Military Tribunal, Nuremberg, 14th of November, 1945, through the 1st of October, 1946. Volume 1, by the International Military Tribunal. Dissenting Opinion, Part 2. 4. Concerning the sentence of defendant Rudolf Hess. The judgment of the tribunal correctly and adequately portrays the outstanding position which Rudolf Hess occupied in the leadership of the Nazi Party and state. He was indeed Hitler's closest personal confidant, and his authority was exceedingly great. In this connection, it is sufficient to quote Hitler's decree appointing Hess as his deputy. I hereby appoint Hess as my deputy and give him full power to make decisions in my name on all questions of party leadership. Transcript, afternoon session, the 7th of February, 1946. But the authority of Hess was not only confined to questions of party leadership. The official NSDAP publication, National Socialist Yearbook for 1941, states that, in addition to the duties of party leadership, the deputy of the Führer has far-reaching powers in the field of the state. These are: first, participation in national and state legislation, including the preparation of the Führer's order. The deputy of the Führer in this way validates the conception of the party. Second, approval of the deputy of the Führer of proposed appointments for official and labor service leaders. Third, securing the influence of the party over the self-government of the municipal units. USA 255, PS 3163. Hess was an active supporter of Hitler's aggressive policy. The crimes against peace committed by him are dealt with in sufficient detail in the judgment. The mission undertaken by Hess in flying to England should be considered as the last of these crimes, as it was undertaken in the hope of facilitating the realization of aggression against the Soviet Union by temporarily restraining England from fighting. The failure of this mission led to Hess's isolation, and he took no direct part in the planning and commission of subsequent crimes of the Hitler regime. There can be no doubt, however, that Hess did everything possible for the preparation of these crimes. Hess, together with Himmler, occupied the role of creator of the SS police organizations of German fascism, which afterwards committed the most ruthless crimes against humanity. The defendant clearly pointed out the special tasks which faced the SS formations in occupied territories. When the Waffen-SS was being formed, Hess issued a special order through the party chancellery, which made aiding the conscription of party members into these organizations by all means compulsory for party organs. He outlined the tasks set before the Waffen-SS as follows. The units of the Waffen-SS, composed of National Socialists, are more suitable than other armed units for the specific tasks to be solved in the occupied Eastern territories, due to the intensive training in regard to questions of race and nationality. GB 267, PS 3245. As early as 1934, the defendant initiated a proposal that the so-called SD under the Reichsführer SS, or Security Service, be given extraordinary powers and thus become the leading force in Nazi Germany. On the 9th of June, 1934, Hess issued a decree in accordance with which the Security Service of the Reichsführer SS was declared to be the sole political news and defense service of the party. GB 257. Thus the defendant played a direct part in the creation and consolidation of the system of special police organs, which were being prepared for the commission of crimes in occupied territories. We find Hess to have always been an advocate of the man-hating master race theory. In a speech made on the 16th of January, 1937, while speaking of the education of the German nation, Hess pointed out, "Thus, they are being educated to put Germans above the subjects of a foreign nation, regardless of their positions or their origin." GB 253, PS 3124. Hess signed the so-called Law for the Protection of Blood and Honor on the 15th of September, 1935. USA 200, PS 3179. The body of this law states that the Führer's deputy is authorized to issue all necessary decrees and directives for the practical realization of the Nuremberg decrees. On the 14th of November, 1935, Hess issued an ordinance under the Reichscitizenship law, in accordance with which the Jews were denied the right to vote at elections or hold public office. GB 258, PS 1417. On the 20th of May, 1938, a decree signed by Hess extended the Nuremberg laws to Austria. GB 259, PS 2124. On the 12th of October, 1939, Hess signed a decree creating the administration of Polish occupied territories. Reichsgesetzblatt No. 210, 1939, page 2077. Article 2 of this decree gave the defendant Frank the power of dictator. There is sufficiently convincing evidence showing that this defendant did not limit himself to this general directive, which introduced into the occupied Polish territories a regime of unbridled terror, as is shown in the letter of the Reich Minister of Justice to the Chief of the Reich Chancellery, dated 17th of April, 1941. Hess was the initiator in the formation of special penal laws for Poles and Jews in occupied Eastern territories. The role of this defendant in the drawing up of these laws is characterized by the Minister of Justice in the following words. In accordance with the opinion of the Führer's deputy, I started from the point of view that the Pole is less susceptible to the infliction of ordinary punishment. Under these new kinds of punishment, prisoners are to be lodged outside prisons in camps, and are to be forced to do heavy and heaviest labor. The introduction of corporal punishment, which the deputy of the Führer has brought up for discussion, has not been included in the draft. I cannot agree with this type of punishment. The procedure for enforcing prosecution has been abrogated, for it seemed intolerable that Poles or Jews should be able to instigate a public indictment. Poles and Jews have also been deprived of the right to prosecute in their own names or join the public prosecution in an action. From the very beginning, it was intended to intensify special treatment in case of need. When this necessity became actual, a supplementary decree was issued, to which the Führer's deputy refers to in his letter. GB 268, R 96. Thus there can be no doubt that Hess, together with the other major war criminals, is guilty of crimes against humanity. Taking into consideration that among political leaders of Hitlerite Germany, Hess was third in significance and played a decisive role in the crimes of the Nazi regime, I consider the only justified sentence in his case can be death. 5. Incorrect judgment with regard to the Reich Cabinet. The prosecution has posed before the tribunal the question of declaring the Reich Cabinet a criminal organization. The verdict rejects the claim of the prosecution, unfoundedly refusing to declare the Hitler government a criminal organization. With such a decision, I cannot agree. The tribunal considers it proven that the Hitlerites have committed innumerable and monstrous crimes. The tribunal also considers it proven that these crimes were, as a rule, committed intentionally and on an organized scale, according to previously prepared plans and directives. Plan Barbarossa, Night and Fog, Bullet, etc. The tribunal has declared criminal several of the Nazi mass organizations founded for the realization and putting into practice the plans of the Hitler government. In view of this, it appears particularly untenable and rationally incorrect to refuse to declare the Reich Cabinet the directing organ of the state with a direct and active role in the working out of the criminal enterprises, a criminal organization. The members of this directing staff had great power, each headed an appropriate government agency, each participated in preparing and realizing the Nazi program. In confirmation, it is deemed proper to cite several facts. 1. Immediately after the Nazi accession to power, on the 24th of March, 1933, there was a law passed entitled The Law of Defense of the People and the State, whereby the Reich Cabinet, besides the Reichstag, was empowered to enact new laws. On the 26th of May, 1933, the Reich government issued a decree ordering the confiscation of the property of all communist organizations, and on the 14th of June, the same year, it also confiscated the property of the Social Democrat organizations. On the 1st of December, 1933, the Reich government issued the law ensuring party and state unity. Following through its program of liquidating democratic institutions, in 1934, the government passed a law of the reconstruction of the Reich, whereby democratic elections were abolished for both central and local representative bodies. The Reichstag thereby became an institution without functional meaning. Transcript, afternoon session, the 22nd of November, 1945. By the law of the 7th of April, 1933, and others, all Reich government employees, including judges, ever noted for any anti-Nazi tendencies or ever having belonged to leftist organizations, as well as all Jews, were to be removed from the government service and replaced by Nazis. In accordance with the basic positions of the German law on government employees of the 26th of January 1937, the inner harmony of the official and the Nazi Party is a necessary presupposition of his appointment to his post. Government employees must be the executors of the will of the National Socialist State, directed by the NSDAP. Defense Document Number 28. On the 1st of May 1934, there was created the Ministry of Education, instructed to train students in the spirit of militarism, of racial hatred, and in terms of reality, thoroughly falsified by Nazi ideology. PS 2078. Free trade unions were abolished, their property confiscated, and the majority of the leaders jailed. To suppress even a semblance of resistance, the government created the Gestapo and the concentration camps. Without any trial, or even a concrete charge, hundreds of thousands of persons were arrested and then done away with, merely on a suspicion of an anti-Nazi tendency. There was issued the so-called Nuremberg laws against the Jews. Hess and Frick, both members of the Reich government, implemented these by additional decrees. It was the activity of the Reich cabinet that brought on the war, which took millions of human lives and caused inestimable damage in property and in suffering borne by the many nations. On the 4th of February, 1938, Hitler organized the Secret Council of Ministers, defining its activity as follows: To aid me by advice on problems of foreign policies, I am creating this secret council. Reichsgestusblatt, 1938, Part 1, page 112, PS 2031. The foreign policy of the Hitler government was the policy of aggression. For this reason, the members of the Secret Council should be held responsible for this policy. There were attempts in court to represent the Secret Council as a fictitious organization, never actually functioning. This, however, is an inadmissible position. It is sufficient to recall Rosenberg's letter to Hitler, where the former insistently tried to be appointed member of the Secret Council of Ministers, to appreciate fully the significance of the council. Even more important practically in conducting aggressive warfare was the Reich Defense Council, headed by Hitler and Göring. The following were members of the Defense Council, as is well known: Hess, Frick, Funk, Keitel, Raeder, Lammers. PS 2194, PS 2018. Göring characterized the function of the Defense Council and its role in war preparations as follows during the court session of the 23rd of June, 1939. The Defense Council of the Reich was the deciding Reich organ on all questions concerning preparation for war. PS 3787, USA 782. At the same time, Göring emphasized the fact that the meeting of the Defense Council always took place for the purpose of making the most important decisions. From the minutes of these meetings, submitted as evidence by the prosecution, it is quite clear that the Council made very important decisions indeed. The minutes also show that other cabinet ministers sometimes took part in the meetings of the Defense Council alongside the members of the Council when war enterprises and war preparedness were discussed. For example, the following cabinet ministers took part in the meeting of the 23rd of June, 1939: of Labor, of Food and Agriculture, of Finance, of Communication, and a number of others, while the minutes of the meeting were sent to all the members of the cabinet. USA 782. The verdict of the tribunal justly points out certain peculiarities of the Hitler government as the directing organ of the state, namely, the absence of regular cabinet meetings, the occasional issuance of laws by the individual ministers having unusual independence of action, the tremendous personal power of Hitler himself. These peculiarities do not refute, but on the contrary, further confirm the conclusion that the Hitler government is not an ordinary rank-and-file cabinet but a criminal organization. Certainly Hitler had an unusual measure of personal power, but this in no way frees of responsibility the members of his cabinet, who were his convinced followers and the actual executors of his program until and when the day of reckoning arrived. I consider that there is every reason to declare the Hitler government a criminal organization. 6. Incorrect judgment with regard to the General Staff and the OKW. The verdict incorrectly rejects the accusation of criminal activity directed against the General Staff and the OKW. The rejection of the accusation of criminal activity of the General Staff and of the OKW contradicts both the actual situation and the evidence submitted in the course of the trial. It has been established beyond doubt that the leadership corps of the armed forces of Nazi Germany, together with the SS party machine, represented the most important agency in preparing and realizing the Nazi aggressive and man-hating program. This was constantly and forcefully reiterated by the Hitlerites themselves in their official bulletins meant for the officer personnel of the armed forces. In the Nazi Party bulletin called Politics and the Officer in the Third Reich, it is quite clearly stated that the Nazi regime is founded on two pillars: the party and the armed forces. Both are forms of expression of the same philosophy of life. The tasks before the party and the armed forces are in an organic relationship to each other, and each bears the same responsibility. Both these agencies depend on each other's success or failure. PS 4060, USA 928. This organic interrelationship between the Nazi Party and the SS on the one hand, and the Nazi armed forces on the other, was particularly evident among the upper circles of military hierarchy, which the indictment groups together under the concept of criminal organization, that is, among the members of the General Staff and the OKW. The very selection of members of the Supreme Command of the Army in Nazi Germany was based on the criteria of their loyalty to the regime and their readiness not to pursue aggressive militaristic policies, but also to fulfill such special directives as related to treatment meted out to prisoners of war and to the civilian populations of occupied territories. The leaders of the German armed forces were not merely officers who reached certain levels of the military hierarchy. They represented, first of all, a closely knit group which were entrusted with the most secret plans of the Nazi leadership. Evidence submitted to the tribunal has fully confirmed the contention that the military leaders of Germany justified this trust completely, and that they were convinced followers and ardent executors of Hitler's plans. It is not accidental that the head of the Air Force stood the second man of the Nazi Reich, namely Göring, that the commander-in-chief of the Navy was Dönitz, subsequently designated by Hitler to be the latter's successor, that the command of the ground forces was concentrated in the hands of Keitel, who signed the major part of the decrees concerning the execution of the prisoners of war and of the civilians in occupied territories. Thus the comparisons made with the organization of the supreme commands in Allied countries cannot be considered valid. In a democratic country, not one self-respecting military expert would agree to prepare plans for mass reprisals and merciless killings of prisoners of war side by side with plans of a purely military and strategic character. Meanwhile, it is precisely such matters that occupied the supreme command of the General Staff and of the OKW in Nazi Germany. The commission by them of the heaviest crimes against peace, of the war crimes, and of the crimes against humanity is not denied, but is particularly emphasized in the verdict of the tribunal, and yet the commission of these crimes has not brought the logical conclusion. The verdict states, "They have been a disgrace to the honorable profession of arms. Without their military guidance, the aggressive ambitions of Hitler and his fellow Nazis would have been academic and sterile." And subsequently, "Many of these men have made a mockery of the soldier's oath of obedience to military orders. When it suits their defense, they say they had to obey. When confronted with Hitler's brutal crimes, which are shown to have been within their general knowledge, they say they disobeyed. The truth is, they actively participated in all these crimes, or sat silent and acquiescent, witnessing the commission of crimes on a scale larger and more shocking than the world ever had the misfortune to know. This must be said." All these assertions in the verdict are correct and are based on numerous and reliable depositions. It remains only incomprehensible why these 100 or so higher officers, who have caused the world and their own country so much suffering, should not be acknowledged a criminal organization. The verdict advances the following reasons for the decision, reasons quite contrary to the facts. A. That the crimes were committed by representatives of the General Staff and of the OKW as private individuals and not as members of a criminal conspiracy. B. That the General Staff and the OKW were merely weapons in the hands of the conspirators and interpreters or executors of the conspirators' will. Considerable evidence disputes such conclusions. 1. The leading representatives of the General Staff and of the OKW, along with a small circle of the higher Hitlerite officials, were called upon by the conspirators to participate in the development and the realization of the plans of aggression, not as passive functionaries, but as active participants in the conspiracy against peace and humanity. Without their advice and active cooperation, Hitler could not have solved these problems. In the majority of cases, their opinion was decisive. It is impossible to imagine how the aggressive plans of Hitler's Germany could have been realized had it not been for the full support given him by the leading staff members of the armed forces. Least of all did Hitler conceal his criminal plans and motivations from the leaders of the High Command. For instance, while preparing the attack on Poland as early as the 29th of May 1939, at a conference with the high military commanders of the new Reich Chancellery, he stated, "For us the matter consists of the expansion of the Lebensraum to the east. Thus the question of sparing Poland cannot be considered, and instead we have to consider the decision to attack Poland at the first opportunity." L79. Long before the seizure of Czechoslovakia, in a directive of the 30th of May 1938, Hitler, addressing the representatives of the High Command, cynically stated, "From the military and political point of view, the most favorable time is a lightning attack on the basis of some incident by which Germany will have been strongly provoked and which will morally justify the military measures to at least part of the world opinion." PS 388. Prior to the invasion of Yugoslavia, in a directive dated the 27th of March 1941, addressing the representatives of the High Command, Hitler wrote, "Even if Yugoslavia declares its loyalty, it must be considered an enemy and must therefore be smashed as soon as possible." PS 1746. While preparing for the invasion of the USSR, Hitler invited the representatives of the General Staff and the OKW to help him work out the related plans and directives, not at all as simply the military experts. In the instructions to apply propaganda in the region, Barbarossa, issued by the OKW in June 1941, it is pointed out that for the time we should not have propaganda directed at the dismemberment of the Soviet Union. USSR 477. As early as the 13th of May 1941, OKW ordered the troops to use any terrorist measures against the civilian populations of the temporarily occupied regions of the Soviet Union. And the same order read, "To confirm only such sentences as are in accordance with the political intentions of the High Command." G50. 2. OKW and the General Staff issued the most brutal decrees and orders for relentless measures against the unarmed peaceful population and the prisoners of war. In the decree of special liability to punishment in the region, Barbarossa, while preparing for the attack upon the Soviet Union, the OKW abolished beforehand the jurisdiction of the military courts, granting the right of repressions over the peaceful population to individual officers and soldiers. It is particularly stated there that crimes of hostile civilians are excluded from the jurisdiction of the courts martial. Suspected elements must be immediately delivered to the officer. The latter will decide whether they should be shot. It is absolutely forbidden to hold suspects for the purpose of bringing them to trial. There are also provisions for the most extreme measures, and in particular, measures for mass violence, if circumstances do not permit the rapid detention of the guilty. In the same decree of the OKW, the guarantee of impunity was assured in advance to the military criminals from the service personnel of the German army. It states there as follows: "The bringing of suits of action, committed by officials of the army and by the service personnel against hostile civilians, is not obligatory even in cases where such actions at the same time constitute military crimes or offenses." In the course of the war, the High Command consistently followed this policy, increasing its terroristic actions with regard to prisoners of war and the peaceful populations of occupied countries. The OKW directive of the 16th of September 1941 states, "At the same time, it must be borne in mind that a human life in the countries in question is frequently held to be of no account, and that a warning example can be made only by measures of exceptional severity." PS 389. Addressing the commanders of the army groups on the 23rd of July 1941, the OKW simply briefed them as follows: It is not in the demand for additional security detachments, but in the application of appropriate draconian measures that the commanding officers must use to keep order in the regions under their jurisdiction. PS 459. The OKW directive of the 16th of December 1941 states, "The troops have the right and are obligated to apply any measures whatsoever, also against women and children, if this contributes to success." USSR 16. Among the most brutal OKW directives concerning the treatment of prisoners of war, one must consider the order entitled Kugel, or bullet. The reasons for resorting to capital punishment for prisoners of war were offenses which, according to international conventions, generally should not carry any punishment, for example, escape from the camp. Another order, Nacht und Nebel, states, "Penalty for such offenses, consisting of loss of freedom and even a life sentence, is a sign of weakness. Only death sentence or measures which entail ignorance of the fate of the guilty by local population will achieve real effectiveness." L 90, USA 224. Transcript, afternoon session, 25th of January, 1946. In the course of the present trial, a great deal of evidence of application of the Kugel order has been submitted. One of the examples of this kind of crime is the murder of 50 officer pilots. The fact that this crime was inspired by the High Command cannot be doubted. OKW also distributed an order for the destruction of the commando units. The original order was submitted to the court. PS 498, USA 501. According to this order, officers and soldiers of the commando units had to be shot, except in cases when they were to be questioned, after which they were shot in any case. These orders were unswervingly carried out by the commanding officers of army units. In June 1944, Rundstedt, the commander-in-chief of the German troops in the West, reported that Hitler's order in regard to the treatment of the commando groups of the enemy is still being carried out. PS 531, USA 550. 3. The High Command, along with the SS and the police, is guilty of the most brutal police actions in the occupied regions. The instructions relating to special regions issued by OKW on the 13th of March 1941 contemplated the necessity of synchronizing the activities in occupied territories between the Army Command and the Reichsführer of the SS, as is seen from the testimony of the chief of the 3rd Department of RSHA, and who was concurrently chief of the Einsatzgruppe D, Otto Ohlendorf, and of the chief of the 4th Department of the RSHA, Walter Schellenberg. In accordance with OKW instructions, there was an agreement between the General Staff and the RSHA about the organization of special operational groups of the Security Police and SD, Einsatzgruppen, assigned to the appropriate Army detachments. Crimes committed by the Einsatzgruppen on the territory of the temporary occupied regions are countless. The Einsatzgruppen were acting in close contact with the commanding officers of the appropriate Army groups. The following excerpt from the report of the Einsatzgruppe A is extremely characteristic as evidence. Among our functions as the establishment of personal liaison with the commanding officer, both at the front and in the rear, it must be pointed out that the relations with the Army were of the best, in some cases very close, almost hearty, as, for instance, the commander of the tank group, Colonel General Hoppner. L 180. 4. The representatives of the High Command acted in all the echelons of the Army as members of a criminal group. The directives of the OKW and the General Staff, in spite of the manifest violations of international law and customs of warfare, not only did not provoke any protest on the part of the higher staff officers of the command of the various groups of the armies, but were inflexibly applied and supplemented by still more cruel orders in the development of such directives. In this connection it is characteristic to note The directive of Field Marshal von Reichenau, Army Group Commander, addressed to his soldiers. The soldier in the Eastern Territories is not only a warrior skilled in the art of warfare, but a bearer of a merciless national ideology. And elsewhere, calling for the extermination of the Jews, von Reichenau wrote, "Thus the soldier must be in full cognizance of the necessity for harsh and just revenge on those subhumans, the Jews." USA 556. As another example, the order of Field Marshal von Manstein, addressed to his soldiers, can be referred to. On the basis of the political aims of the war, the Field Marshal cynically appealed to his soldiers to wage the war in violation of the recognized laws of warfare in Europe. USA 927. Thus, in the course of the hearing of evidence, it has been proven beyond all doubt that the General Staff and the High Command of the Hitlerite Army comprised a highly dangerous criminal organization. I consider it my duty as a judge to draw up my dissenting opinion concerning these important questions on which I disagree with the decision adopted by the members of the Tribunal. Soviet Member, International Military Tribunal. Major General Jurisprudence. Signed, I.T. Nikitchenko, 1st of October, 1946. End of section 44. Section 45 of Trial of the Major War Criminals, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Trial of the Major War Criminals before the International Military Tribunal, Nuremberg, 14th November 1945 through 1st of October 1946. Volume 1, by the International Military Tribunal. Sentences. In accordance with Article 27 of the Charter, the President of the International Military Tribunal, at its concluding session of October 1, 1946, pronounced the sentence on the defendants convicted on the indictment. Defendant Hermann Wilhelm Göring, on the counts of the indictment on which you have been convicted, the International Military Tribunal sentences you to death by hanging. Defendant Rudolf Hess, on the counts of the indictment on which you have been convicted, the tribunal sentences you to imprisonment for life. Defendant Joachim von Ribbentrop, on the counts of the indictment on which you have been convicted, the tribunal sentences you to death by hanging. Defendant Wilhelm Keitel, on the counts of the indictment on which you have been convicted, the tribunal sentences you to death by hanging. Defendant Ernst Kaltenbrunner, on the counts of the indictment on which you have been convicted, the tribunal sentences you to death by hanging. Defendant Alfred Rosenberg, on the counts of the indictment on which you have been convicted, the tribunal sentences you to death by hanging. Defendant Hans Frank, on the counts of the indictment on which you have been convicted, the tribunal sentences you to death by hanging. Defendant Wilhelm Frick, on the counts of the indictment on which you have been convicted, the tribunal sentences you to death by hanging. Defendant Julius Streicher, on the count of the indictment on which you have been convicted, the tribunal sentences you to death by hanging. Defendant Walter Funk, on the counts of the indictment on which you have been convicted, the tribunal sentences you to imprisonment for life. Defendant Karl Donitz, on the counts of the indictment on which you have been convicted, the tribunal sentences you to 10 years imprisonment. Defendant Erich Raeder, on the counts of the indictment on which you have been convicted, the tribunal sentences you to imprisonment for life. Defendant Baldur von Schirach, on the count of the indictment on which you have been convicted, the tribunal sentences you to 20 years imprisonment. Defendant Fritz Sauckel, on the counts of the indictment on which you have been convicted, the tribunal sentences you to death by hanging. Defendant Alfred Jodl, on the counts of the indictment on which you have been convicted, the tribunal sentences you to death by hanging. Defendant Arthur says inquart. On the counts of the indictment on which you have been convicted, the tribunal sentences you to death by hanging. Defendant Albert Speer. On the counts of the indictment on which you have been convicted, the tribunal sentences you to 20 years imprisonment. Defendant Konstantin von Neurath. On the counts of the indictment on which you have been convicted, the tribunal sentences you to 15 years imprisonment. The tribunal sentences the defendant Martin Bormann on the counts of the indictment on which he has been convicted to death by hanging. Tabulation of sentences, 30th of September 1946. Footnote: these sentences were read in open court by the President on the 1st of October 1946. End footnote. Defendant Hermann Wilhelm Göring. Counts on which convicted 1, 2, 3, and 4. Sentence: death by hanging. Defendant Rudolf Hess. Counts on which convicted 1 and 2. Sentence: imprisonment for life. Defendant Joachim von Ribbentrop. Counts on which convicted 1, 2, 3, and 4. Sentence: death by hanging. Defendant Wilhelm Keitel. Counts on which convicted 1, 2, 3, and 4. Sentence: death by hanging. Defendant Ernst Kaltenbrunner. Counts on which convicted 3 and 4. Sentence: death by hanging. Defendant Alfred Rosenberg. Counts on which convicted 1, 2, 3, and 4. Sentence: death by hanging. Defendant Hans Frank. Counts on which convicted 3 and 4. Sentence: death by hanging. Defendant Wilhelm Frick. Counts on which convicted 2, 3, and 4. Sentence: death by hanging. Defendant Julius Streicher. Counts on which convicted 4. Sentence: death by hanging. Defendant Walter Funk. Counts on which convicted 2, 3, and 4. Sentence: imprisonment for life. Defendant Hjalmar Schacht. Sentence: not guilty. Defendant Karl Donitz. Counts on which convicted 2 and 3. Sentence: 10 years imprisonment. Defendant Eric Rader. Counts on which convicted 1, 2, and 3. Sentence: imprisonment for life. Defendant Baldur von Schirach. Counts on which convicted 4. Sentence: 20 years imprisonment. Defendant Fritz Sackel. Counts on which convicted 3 and 4. Sentence: death by hanging. Defendant Alfred Jodl. Counts on which convicted 1, 2, 3, and 4. Sentence: death by hanging. Defendant Franz von Papen. Sentence: not guilty. Defendant Arthur Sayce Inquart. Counts on which convicted 2, 3, and 4. Sentence: death by hanging. Defendant Albert Speer. Counts on which convicted 3 and 4. Sentence: 20 years imprisonment. Defendant Konstantin von Neurath. Counts on which convicted 1, 2, 3, and 4. Sentence: 15 years imprisonment. Defendant Hans Fritzsche. Sentence: not guilty. Defendant Martin Bormann. Counts on which convicted 3 and 4. Sentence: death by hanging. Signed, Jeffrey Lawrence, President. Signed, Francis Biddle. Signed, H. Donadieu Davabre. Signed, Nikitchenko. A true copy. Signed, John E. Ray, Colonel F.A. End of section 45. End of Trial of the Major War Criminals before the International Military Tribunal, Nuremberg, 14th of November, 1945 through 1st of October, 1946, Volume 1, by the International Military Tribunal.